Good afternoon. The Senate Finance Committee is now in session, and we will start our hearings with Delegate McIntosh, House Bill 775. Senator, take the time that you need to lay out the parameters of your bill.
Thank you very much, Madam Chair, members of the committee. It's great to see you. I am here to present actually House Bill 775, which is the Maryland Pediatric Cancer Fund Establishment and Income Tax Checkoff. This bill actually is very much like a cross-file, or a bill that is cross-filed and originated in the Senate from, I think it was Delegate Jackson. I now have that bill in the Appropriations Committee, and you have my bill over here. But the differences in the bill is the way they collect the money. Basically, House Bill 775 would establish this Maryland Pediatric Cancer Fund and Maryland Pediatric Cancer Advisory Committee to review and evaluate requests for funding from the fund. It also would require the Secretary of Health to adopt regulations to implement the Pediatric Cancer Grant Fund. I was basically approached by several parents and organizations that work with children and families who have children who are suffering from cancer and asked to try to establish this in Maryland. It's been established in other states. And as a grandmother of a little girl who lives in Montgomery County, and has been going through for the last year and 7 months treatment for cancer. And I know very well what families go through because of this. The good news is she has been cured of the cancer. The bad news is she's got a few more months of chemo to go, just as a protection. But cancers in children like her are being cured every day. But the families and the children need our help to really target some research and target some attention to childhood cancer. And so that's what this bill does. I would also note that in the budget that we will be passing in a couple of days on both sides, the Senate had set aside funding to establish this, and we on the House side, of course, agree. So I hope that you will pass this bill, and I would also suggest that you conform this bill to Senator Jackson's approach, and I would be very happy. I'm going to pass his bill on the Senate side.
Okay,
Thank
I was
you.
about to ask you about that. That's helpful. Are there questions? All right, thank you very much.
Thank you. It's a pleasure seeing all of you.
Okay, for
Have
us
a good
to-
last 2 weeks, okay?
Okay, you too.
Oh, that's me.
All right.
I'm sorry.
Senator
guys have
Kramer,
fun.
you're up next with House, oh, you got the crossfire. Okay. All right.
Yes, ma'am. Do you want me just to do it from my
Montgomery
seat?
County delegation.
Would you like me to do it from here, or would you like me to go up, Madam Chair?
You could go up.
Okay. Thank you, Madam Chair, Mr. Vice Chair, members of the committee. Ben Kramer here introducing House Bill 1340, which is a local Montgomery County delegation bill. And the bill just broadens the definition of members of the district, which is in existing statute, to include commercial tenants for provisions of law governing business improvement districts located in Montgomery County. The Board of Directors of a Business Improvement District Corporation, Montgomery County, consists of at least 11 members. However, Montgomery County or one of its municipalities in which a district is established may determine a different number of board members if the district is connected with a business improvement district in another county, state, or the District of Columbia. Colleagues, this predominantly involves downtown Silver Spring, and a lot of good work that has been going on with the residential community, the business community there in the Central Business District, and tenants. So the bill has passed unanimously in the House. Madam Chair, I am hoping that we do have the appropriate documentation from the Montgomery County Senate delegation indicating that we have supported the bill unanimously.
Thank you very much. Are there any questions? All right, if not, we appreciate your testimony.
Thank you, ma'am.
Okay. Delegate Chang, House Bill 178.
Good afternoon, Madam Chairwoman Kelly, Vice Chairman Feldman, and the members of the Senate Finance Committee. Good afternoon. This afternoon, I'd like to present to you House Bill 178. This deals with the public health cottage food business annual revenues. What the bill does, it increases the current limits of $25,000 on the annual revenues up to $50,000. As we all know, with inflation and also with the supply chain issues and the rising cost of goods, it's important to be able to help our small businesses, especially these businesses, the cottages business, and helping them increase their revenues. The cost of goods have gone up, and so helping them out, raising the limit from 25 to 50 would be an extraordinary to help to them. These cottage businesses, they produce non-hazardous items that are sold in farmers markets and all the types of modes like that, and they also have labels on them which are required by the Maryland Department of Health. And since the cottage food business program has been implemented in the state of Maryland, there has not been any foodborne illnesses reported. So it's a pretty safe part of our economy, and any way we can help them out would very much appreciate it. Thank you very much to the committee for consideration of favorable report.
Thank you. Are there any questions? All right, here none. Thanks for your testimony.
Thank you very much.
All right, we're going next to Delegate Valentino Smith on House Bill 456.
Thank you, Madam Chair, members of the committee. I can honestly say I'm almost giddy. This is only the second time in 2 years I've been before a full working committee, so I'm just going to take it in for a minute, but thank you. So, yeah, you could keep it, let's keep it interesting. So I'm here today on House Bill 476, and it really addresses food insecurity for our most vulnerable seniors. What it does is it adds to our state supplemental SNAP program a benefit of no less than $40 for those that are 62 years and older. You know, I think you all know that SNAP helps to alleviate hunger and it improves the well-being, because good nutrition for our seniors is crucial to them maintaining their physical and mental health. I'm starting to appreciate that. In 2016, you might recall that as the General Assembly, we decided to create a state minimum benefit of $30, and at that time it was a doubling of the federal benefit, which was $15, so we went to $30. The current federal minimum benefit is $20, so I do give Governor Hogan credit. In his budget, he moved and doubled it to $40 in his current budget. So we need to pass this bill to create the statute so that it's $40 going forward. To qualify for SNAP, you have to be at less than 165% of the federal poverty level. That's about $1,700 a month, or for a household, $2,396 a month. So we all know for our seniors that are on Social Security or on pensions, they really don't get an increase. And so the most basic need, if any of you were hungry today when you're on the Senate floor, the most basic need we have is to address hunger and food. What I want to just emphasize while I have a few minutes here with you is that during the pandemic, everybody received an emergency supplemental SNAP benefit of about $250 a month. So we never spent in the last 2 years any of the money. About $6 million was never spent on the state supplemental SNAP program. Maryland has the 8th highest food insecurity rate in the nation for those 60 years and older. So providing this additional benefit might bring us a little bit closer. Inflation on food right now is about 5% for 2022. If any of you have gone to the grocery store, you've probably had a little bit of reality check. I think it's crazy how much food is costing right now, but I can imagine for our seniors. The other thing I really want to emphasize while I'm here is that for every dollar we spend on SNAP, our own local businesses see about $1.80 in economic activity. In 2020, the Senate on Budget and Policy Priorities found that when we give SNAP benefits, it's one of the fastest impacts on our economy because the money is so quickly injected back into the economy. 80% are spent within 2 weeks, and usually the rest within 30 days. And it can only be spent on certain items and is spent right back here. For every dollar we give these 60-year-old, 62-year-old seniors for food, they then can spend what they need to spend on transportation, gas, and shelter. So I'm urging a favorable report, but before I leave, Madam Chair and members of the committee, what I'd like to suggest is Senator Wallstreicher has Senate Bill 957, which is the cross-file, and its original form, it suggested that we move this benefit from 62 to 60, or from 40 to 45. So in the Senate's wisdom, if you see fit to work with the senator's bill and the provisions that are a little bit more generous, I would urge a favorable report. Thank you.
Okay, thank you very much. Are there any questions?
Oh, come on, I haven't been out in 2 years to a committee.
Okay.
Thank you.
Thank you. Okay.
Yeah, she's on economic matters. doing time.
Okay, we are going to call the House Bill 496. It's Delegate Valderrama, and her aide is going to explain the bill. If you'll come up, Carol.
Good afternoon. Thank you, Madam Chairwoman.
Pull that mic a little closer to you. It's
Sure.
movable.
Is that better?
Yes.
Okay. So as Delegate Valderrama could not be here today because ECM is taking up 275, the version of her cross-file on family and medical leave insurance. As members of this committee well know, the General Assembly has considered a family medical leave insurance program for at least the past 7 years. Hours have been spent hearing testimony, asking experts questions, and considering countless pages of testimony. The legislation enacting a program was first introduced by Ariana Kelly in 2015, but was withdrawn by the sponsor. In 2016, the General Assembly directed a task force to make recommendations regarding the development of a state medical leave insurance policy by December 1st, 2017. And Senator Feldman was on that original task force. Delegate Valderrama introduced legislation to enact the recommendations of the task force in 2020, 2021, and 2022. Last week, this committee reviewed the amended Senator Hayes's cross-file of my original bill, which was passed by the Senate and is being voted on in the Economic Matters Committee as I speak. HB 496 presents an alternative approach to Senator Hayes's bill. It was originally Chair Wilson's bill, and Chris is now the chair, or the sponsor of that bill, I'm sorry. It establishes yet another commission to study and make recommendations for the establishment of a medical leave insurance program, which will consider a number of things: the employer-employee split, leave benefits, the use of outside contractors, timing issues of the program, as well as an actuarial analysis about the sustainability of the fund. This report would be due to the governor on December 1st of this year. Further, the legislation sets aside $25 million to prepare for the implementation of the leave program and another $750,000 for costs and consultation fees. As we await the outcome of the ongoing discussions between the House and the Senate on HB 275, I want to thank you for your work on and consideration of a family medical leave insurance program.
Thank you. Are there any questions? Okay, seeing none, we thank you for testifying. Okay. Okay. All right, we got Delegate Resnick's Bill 373, and I understand that Sarian, the staff person, will testify.
Yes. Thank you, Madam Chair, members of the Senate Finance Committee. I'm here on behalf of Delegate Resnick to introduce HB 373, which would set minimum staffing requirements for the Office of the Chief Medical Examiner, or OCME. This bill would prohibit OCME from exceeding staffing to autopsy ratios that would cause a Phase 2 violation with the office's accrediting body. This is a complex issue, but significantly important to the work of the department and healthcare in our state. As news reports have indicated, up until quite recently, we literally had bodies piling up in Maryland. The Department of Health's Office of the Chief Medical Examiner has allowed staffing levels to drop so much that we are in a crisis dealing with the number of autopsies that need to be performed in a timely manner. DLS budget analysts have reported to the HSS subcommittee that OCME has been at a minimum of Phase 1 violations for the last 10 years. A Phase 1 violation means that the autopsy to staff ratio has exceeded 250 per year. Over the course of the last year, we are well past a Phase 2 violation, which is not our first time in recent years, which means we exceed 325 autopsies per medical examiner per year. As of the House hearing on February 16th, statistics showed that the office was at 390 autopsies. The only reason we did not receive a Phase 2 violation, which could jeopardize the office's accreditation, is that the National Association of Medical Examiners, or NAME, has suspended investigations during the pandemic. Up until a few weeks ago, the office did not have proper storage of the remains in their care, with decedents' bodies being stacked in the halls of the office for days at a time, if not longer. Only at the beginning of February did the department finally procure 2 refrigerated storage trailers, providing proper storage for all remains for the first time in months. Not only was this situation disrespectful, but improper storage risks spoiling the pathology of autopsies, potentially defeating the purpose of the OCME examinations. The problem got so bad that the state requested assistance from FEMA in order to assist in clearing the backlog. Let me repeat that. FEMA, the federal agency responsible for assisting during disasters, was asked for help. The department will be quick to point out that every state is experiencing a shortage of pathologists and that our problem is not unique. However, to the best of my knowledge, we are the only state to have admitted, by virtue of this request, to having a full-fledged disaster on our hands, though man-made rather than natural. FEMA is the only reason the backlog was cleared. This is not a new problem. As chair of the Health and Social Services Subcommittee on Appropriations, Delegate Resnick has had this discussion with the department every year. For 6 years, we have heard the excuse that the positions are difficult to recruit. The department has not hired new pathologists since 2019, well before COVID, and only this year made significant changes to the salaries of the positions. Instead, the department has opted for per diem personnel to come in on nights and weekends, often flown in from other states at our expense, to deal with the backlog. Last year, 5 pathologists retired, only to be rehired as per diems by the same office, getting a higher daily rate for clearing the backlog of less complex cases, creating an even larger morale problem within the office. Other pathologists have left the office to go to jurisdictions who provide higher pay or a smaller caseload and better work-life balance. It is time to hold the department accountable. This bill passed out of HGO unanimously with one sponsor amendment to clarify who is responsible for enforcement, which is the department, and passed out of the House 132-0. I ask the committee for a favorable report.
Thank you. Sounds like we really have to solve what's become an emergency. I've willed my body to the anatomy board. I want to know that they'll be able to use whatever they find out, whether it's scientific knowledge or body parts to help somebody or whatever it is they're going to do with it.
Yes. You'll be reassured to know that the body who deals with donations is separate from the medical examiner's office, but yeah, it is still pretty closely tied.
Okay, are there questions? Okay, thank you very much. You did a
Thank
good
you.
job. Okay. Okay, we're going to House Bill 526, the Prince George's County Delegation and Montgomery. Guy Andes. Okay.
Good afternoon, Madam Chair, members of the committee. For the record, Guy Andes, Government Affairs Manager for WSSC Water, here to present House Bill 526. House Bill 526 will authorize WSSC Water, in addition to other penalties, to impose a penalty not exceeding $5,000 for each violation to persons who violate provisions of the Maryland Annotated Code, Public Utilities Article 29101. What exactly is that? That is any violation of the WSSC Plumbing and Fuel Gas Code, Plumbing and Fuel Gas Code that WSSC is authorized to promulgate under the regulations, under the law 29101. As a bi-county state agency, this will put us on parity with the State Plumbing Board. Right now, WSSC has a progressive fine structure, which after the fourth offense, a violator is only subject to a $1,000 fine. This would allow us to increase that fine up to, and including that $1,000 fine, and include a $5,000 fine for such violations. I'm here to answer any questions you have and request a favorable report.
Are there any questions? Senator Benson?
Yes, thank you very much. So what I hear you saying is that we're seeing a significant increase in the fact that we now have companies that are ignoring WSSC as a regulatory agency. Is that what I'm hearing you say? It has an increase, we've had
In a
an
roundabout
increase?
way, yes, ma'am, Madam Senator.
That's what it is?
The $1,000 fine that a violator receives after the fourth violation is not a big enough deterrent to,
So they keep on doing it?
they keep on doing,
They
yes,
pay the
ma'am.
$1,000 and keep it rolling?
Right, yes, ma'am.
Oh, I see. So now we're saying, well, since you didn't hear it with 1,000, we'll fix you with 5,000.
Correct.
Oh, I see. Okay, all right.
All
So
right.
in other words, we're seeing a significant increase in people who are, is this a result of the pandemic, or has this been an ongoing problem?
It's been an ongoing problem.
It's been an ongoing problem.
Yes, ma'am.
All right, thank you.
You're welcome.
All right, any other questions? Thanks so much for your testimony.
Thank you, Madam Chair.
Okay. All right, we're going next to Senate Bill 436, Delegate Wells, Motor Vehicle Insurance Use of Credit History Rating Policy.
Good afternoon, thank you.
And since we do have some witnesses on this bill, let me call up some to the table. Bryson Popham, who's favorable with amendments, Bob Enton, Matt Overturf. Okay. And when she finishes explaining the bill, you guys will have 2 minutes each. And the mics are movable.
Great. Thank you, Madam Chair. Chair Kelly, Vice Chair Feldman, and members of the Finance Committee. For the record, I am Delegate Melissa Wells. I'm here to testify on House Bill 436. House Bill 436 has passed. Out of the House will require auto insurance providers that use credit history as part of their policy rating to accept by written request from the customer exceptions to the insurer's policy of using credit history when the applicant or insured has experienced specified events that directly influence the applicant's or insured's credit information. In addition, this request, beginning July 1, 2023, and every 6 months thereafter, an insurer who has received a request for a reasonable exception within the immediately preceding 6 months must submit to the Maryland Insurance Administration the number of requests submitted, the outcome of each request, and the specified demographic information about that request, and the criteria used by the insurer to determine whether to approve or deny each request. This valuable data will help us determine further actions needed by this body. While I do wish this legislation would go further and completely remove the use of credit history in auto insurance ratings, I understand the Economic Matters Committee position on this issue. My constituents in the 40th District in Baltimore City have among the highest rates of auto insurance in the state. Even after explaining the amended bill, an overwhelming number of my constituents would like to see this bill pass, even though it is not perfect. It is with this that I ask for your support for House Bill 436.
Are there questions? All right, then we'll go to the panel, and everybody's favorable with the amendment, so be sure we understand your amendment as well as.
So if I might, Madam Chairman, Robert Enton on behalf of the American Property Casualty Insurers Association. This is one of the few years since 2002 when this bill passed out of the credit bill passed out of the Senate Finance Committee that you haven't had a bill to ban the use of credit in front of you. However, you've never passed a bill to enact a ban. I think the committee's always recognized that Maryland as one of we have 47 states that have no limitations on credit whatsoever. We have 3 that ban it. Maryland has the most comprehensive consumer protections in the United States that go with the use of credit. I'm not going to go into all the details about how the use of credit current statute works. As I say, it's one of the most consumer-friendly statutes in the country. We're here to talk about House Bill 436. And House Bill 436 puts in a whole new process for insurers to make exceptions if a consumer, if an insured has a life-impacting event occur in their lives, something which may either through illness, through loss of a job, whatever it is, that might have caused their credit rating to go down. This puts in statutory requirements for insurers to consider those issues, including a requirement that the insurer notify its insureds that if they have one of these life-changing circumstances, they can apply, that's affected their credit rating, they can apply for relief from the carrier. So we're here today for the insurance industry to say we support this bill. We support it. We worked on it. We support it. This is what we call the NCOIL national version of this bill. It's been enacted in 29 states all over the country, from Connecticut to California. And NCOIL is the National Conference of Insurance Legislators. It's legislators from all over the country. It's not an insurance group. It's not insurance company people. It's legislators like you. And in fact, Delegate Valderrama and Delegate Courtney Watson are currently on the Property and Casualty Insurance Committee of NCOIL, and this is their model, and we support it. Now, I'm amazed, quite frankly, Madam Chairman and members, that when I found out who was testifying in opposition to the bill, it's the consumer groups. Auto Consumer Alliance, Job Opportunities Task Force, and the Maryland Consumer Rights Coalition. They didn't come in favorable with amendments and say return the bill, to its original form. They're opposed. They're opposed, and they're opposed because they didn't get what they wanted, which is a ban on credit. But I'm quite frankly amazed that they would be here today, and we're supporting this additional obligation on the part of carriers, which can only benefit consumers. Maybe it doesn't benefit them as much as far as they want to see them benefit it, but it is a benefit. And yet they're opposed to the bill. This was the spirit of compromise from the Economic Matters Committee, from ECM, to go ahead and move the ball forward in offering consumers additional protections. We do have amendments. You have written testimony from the MIA information. And what that testimony says is that the MIA notes that insurers do not presently collect income, race, and ethnicity information for underwriting or rating purposes, and doing so would violate current Maryland insurance law. Private passenger vehicles insurers are not permitted to consider such factors as race, ethnicity, or income in underwriting or pricing. And what the bill does is the bill at the very end requires the carriers to report this information to the MIA every 6 months. We agree with the MIA that this is not permitted under current Maryland law, and we think it would be a mistake to include it. If there's information that the legislature thinks that the MIA, and I know that the commissioner is in the room today, could provide, that's fine with us. But those provisions, we believe, should be stricken. So I thank you for allowing me to speak, Madam Chairman. I'd be happy to answer any questions. We strongly support the bill with those amendments that we've discussed. Thank
Are
you.
there any questions for Bob? Bob, I will tell you, I attended NAIC meetings where Ann Coyle participated for 16 years, and they're good guys, so they're a little more conservative than we are.
Well, Madam Chairman, I thought that was the case, and I looked at your biography to see, and I looked at the NCOIL website, and they didn't list your name. That's why I didn't mention it.
I didn't attend as Ann Coyle's representative.
Thank you.
But I was there. Okay.
Thank you, Madam Chair. Madam Chair, members of the committee, my name is Matt Overturf. I'm the Regional Vice President for the National Association of Mutual Insurance Companies. NAMIC is the nation's largest property and casualty trade association with more than 1,500 members. And we appreciate the consideration of House Bill 436 and the addition of the extraordinary life circumstances language. The ELC, as Bob mentioned, is a national model that NAMIC supports across the country and has done so in Maryland in the previous years, and we do so again this year. Unfortunately, in the House, additional language was included to create a reporting mechanism that is problematic for NAMIC and our members. While the ELCs are a valuable consumer protection, the additional reporting requirement is an unnecessary step with no benefits to anyone involved. Provision 3 of Section 6 is particularly problematic, as it would require insurers to collect specific, sensitive, protected class demographic data on every policyholder who applies for the ELC exemption. Simply put, property and casualty insurers do not collect this data today. That would be income, race, ethnicity from their policyholders, and don't want to ever. For this reason, NAMIC requests an amendment to Section 6 that would require insurers to report the number of exemptions requests received and granted in the reporting period. And with that amendment, NAMIC would support House Bill 436. I appreciate the opportunity to appear before the committee today.
Thank you. Are there any questions for this witness? Senator Hayes.
Thank you, Madam Chair. The testimony was that you guys don't collect any of the demographic information, but you do have access to it. You can't use it to make decisions on it, right?
No, we don't have access to it.
So you don't have access to.
We don't have access to race,
Bob, whoa,
ethnicity.
you're talking
Sorry,
over me.
ethnicity.
You're talking over me, Bob.
sorry,
I wasn't even asking you the question. Thank you. Appreciate it. My question was, like, information that you do collect, like zip code information, is there any opportunity, and this is education for me, is there any opportunity that information can be dissected to determine, like, the demographic in that area?
I would just say this, Senator Hayes, that I've been in hearings, I've represented the industry for decades, and I've been in hearings where people have talked about zip codes.
Mm-hmm.
So I assume that data is available. We're going to have somebody's address on every application that we receive and every policy that gets written. I don't know that there's no mandate today for us to report zip code information, but I don't know that there's any prohibition on it.
Yeah, I hear what you're saying about, like, to collect a specific amount information on race and stuff like that may be a problem, but you do, I would imagine insurers do have some proxy information based off of locale and stuff like that on the demographics that's represented in those areas.
Correct.
Gotcha. Thank you, Madam Chair.
Okay. All right, and Bryson.
Thank you, Madam Chair. Members of the committee, Bryson Popham, appearing before you today in support of House Bill 436 with amendments on behalf of 3 clients: Agency Insurance Company, the Maryland Association of Mutual Insurance Companies, which is Mr. Overturf's state affiliate, and also the insurance agents and brokers. I'm here really for a narrow purpose. It does go to Senator Hayes's question a minute ago, and that is the collection of information that, as the insurance commissioner has advised you, is impermissible under I believe both state and federal law. What is my piece of information that's a little bit different? Well, we have, I think, a little under 200 automobile insurers doing business in Maryland. We have literally thousands, perhaps tens of thousands of insurance agents. And I can tell you that if there comes a time when information has to be collected from insurers, and those insurers use agents, then the request is going to go to agents. They do not collect this information either. They have told me they don't want to collect this information. This would be an enormous burden on them for really no benefit whatsoever. And for that reason, we are supporting the amendment that Mr. Overturf has presented to the committee. Senator Hayes, to your question, I do represent insurers. I can tell you they do not use zip codes in any kind of proxy fashion. They don't have the capability. Now, I'm talking about smaller insurers today. I can't speak to the larger ones. But the insurers that I am testifying on behalf of today would not be able to do what you have asked about.
Okay, are there any other questions? All right, thank you so much.
Thank you, Madam Chair.
Thank you, Madam Chairman.
All right, now we're going to the unfavorables. Isadora Stern, representing the Maryland Consumer Rights Coalition, Franz Schneiderman, Consumer Auto, and Christopher Dews, JOTF. And the mics are movable. All right, who'd like to go first?
Ladies first, or?
Yeah, ladies first, okay. Good afternoon, Madam Chair, Vice Chair, and members of the committee. My name is Isadora Stern, here with the Maryland Consumer Rights Coalition. MCRC is a statewide nonprofit that works to advance economic inclusion and equity through our education, direct service, and our advocacy. And unfortunately, we are here in opposition, as Mr. Enton pointed out. Firstly, I would like to thank Delegate Wells for introducing this legislation. In its original posture, the bill would have eliminated the use of credit score in auto insurance ratings. Unfortunately, now with the amendments, the bill will allow the continued use of credit score in the rating process, which advocates find very challenging because credit score will perpetuate the use of racial and economic discrimination in the rating system. And it's also a matter of public safety. The use of credit score will allow insurance companies to use a factor that signifies a historic disinvestment in Black and brown communities, and one where people of color have significantly fewer opportunities to build credit compared to their white counterparts because of systemic barriers to financial security. This is also a matter of public safety because insurance companies are allowed to use credit score. They weigh this factor as heavily as they do driving-related factors, such as the use of, such as accidents and number of DUIs. And the way this is playing out in Maryland now, we see that someone with excellent credit, but who has a DUI, so who is driving while intoxicated, will pay less in insurance than someone who has, unfortunately, a poor credit score, but a perfect driving record. So we are concerned that this, while as amended, that the bill will continue the use of credit scores in the rating process. And we see that this, clearly by who is on the table in the panel before us, this is an industry-serving bill and one that will not protect your constituents and will not protect Marylanders and working families. So unfortunately, I have to urge you to give an unfavorable report to this bill with the weakening amendments. Thank you.
Okay, are there any questions for this witness? All right.
I will go next. Good afternoon, members of the committee. My name is Christopher Dews. I'm the Senior Policy Advocate of the Job Opportunities Task Force, here today, unfortunately, opposing the bill that we had given to the wonderful Miss Delegate Melissa Wells. We reached out to her because this was a serious issue for us. Just to give you some statistics, this is from the MVA, 11% of Baltimore City residents, 11.5% of Montgomery County residents, 16% of Baltimore County residents, and 22.8% of Prince Georgians drive uninsured. They drive uninsured primarily because of the cost of uninsurance. And this data that I just cited to you was from 2015. When you look at numbers from 2021, over 14.1% of Marylanders drive uninsured. That's about 602,000 persons. That's a public safety issue. The bottom line is we've got over 600,000 Marylanders who do not drive with insurance primarily because they cannot afford it. And this is specifically located in the 4 largest jurisdictions. Now, we gave this specific piece of legislation to Delegate Wells for the sole purpose of lowering the cost of auto insurance. Bankrate did a study which basically said that if you have excellent credit, you are paying, on average, in the state of Maryland, $1,565, which is, let's just round round that down to $1,500. However, if you have poor credit, you are paying $2,935. In a nutshell, if you have poor credit, you are paying double what somebody with excellent credit is paying, which is leading to an increased amount of individuals driving uninsured simply because they cannot afford it. The reason why we are even attacking the credit history issue is not because we want smoke with the insurance industry. A business has got a business. We simply want to reduce the cost. The bill as amended does not reduce the cost of auto insurance. What it does is it allows an individual, if they have experienced a catastrophic emergency, to apply for a specific exemption to lower their cost. However, it does not say that the insurance provider has to reduce the cost, and also the individual would have to prove with verification that the specific incident has happened to them, and that includes death of a spouse, a divorce, serious illness, things of that nature. The last thing I will say is that when it comes to credit history specifically, according to the Urban Institute in 2019, they stated that over 50% of Caucasian Americans have a credit score of over 700. And yet only 21% of African Americans have that same height. So that being said, this disproportionately will affect, it is currently affecting lower income African American communities. Only 9% of the jobs in the Baltimore region can be reached within 1 hour one way by public transit. That being said, if an individual cannot afford a car, if they cannot afford auto insurance, then they simply cannot get to work. And as a Job Opportunities Task Force, it is our mission to ensure that lower income individuals can secure employment, and they cannot do that if they cannot afford auto insurance, and that's the reason why we pushed this bill. However, as amended, it does not lower the cost of auto insurance for our constituency, specifically in Prince George's County, Baltimore City, and Montgomery. And for those reasons, we urge an unfavorable report on this piece of legislation.
Okay, are there any questions? Senator Reedy.
Thank you, Madam Chair. This is a question maybe for the whole panel, or not for the whole panel to answer, one person to answer it. But, you know, I love the Job Opportunities Task Force. I love the point of view you guys come from. We don't always agree on the bills that you're putting forward. I don't necessarily, but I know where the heart is. But my question would be, there is such a thing as getting half a loaf. So that's my one question is, why are you all, at this late hour, opposing some progress on the issue when that's probably the progress you can get this session? My second question is, and maybe a little more substantive, the folks that you're referencing, 600,000 people driving uninsured, which we agree is not a good thing. MAIF is available. We've passed legislation that hopefully is going to get through the House that will allow for there to be payment plans, which I support, letting people have payment plans. So can you square that circle for me that we would want to spike a bill with someone who's partnered with you over this issue?
Well, I will speak to the first half of that, and I'll actually pass it to either Mr. Schneiderman or Ms. Stern to talk about MAIF specifically. For us, the number one issue is that it's not necessarily progress. It allows an individual to, let me say this in the reverse way. As you probably heard from former testimony from Mr. Anderson himself, you will continually hear, in 2002, we made a compromise. In 2002, there was a deal that was made. Our concern, if I'm going to be 100% transparent, is that this conversation now, saying that this was a compromise that was made and that it's a move forward, is going to lead to, in 2023, 2024, 2025, saying, hey, in 2022, we had a deal, we made a compromise that simply said that you can apply for this catastrophic emergencies provision. We don't necessarily see it lowering the cost of auto insurance. It also does not necessarily guarantee that an individual will have a decreased rate. There is the reporting mechanism, which Delegate Wells has mentioned, but we just don't see this as a proper move in the right direction. So it's not necessarily a move forward. It's kind of a step to the side, and we don't necessarily see it as beneficial or lowering the cost for pretty much anybody.
Okay, can I ask about, so the MAIF, just one person, the MAIF question, what's the deal? Why? Because some people are driving uninsured, let's be honest, because they don't want to do it. There are people who can't afford it. I mean, or let's put it this way, so some people make the choice that they'll risk it. Some people really are in difficult situations. A lot of them may be. So that's my question is, if we're gonna have a MAIF payment plan, how does that help?
I think a MAIF payment plan is helpful, and I've supported that. I mean, the problem is MAIF remains really expensive, so it's not a good solution for affordability for people who are burdened with very high-cost auto insurance. We've been looking for ways to make it more affordable for people.
But we do, okay. All right, no, that's fine. Thank you very much.
Thank you.
Okay, Senator Bidle?
Thank you, Madam Chair. Just for one person on the committee, I didn't get the name of the young lady on the end, but. Thank you. So why do you think insurance companies use credit? Why is that an important rating factor for insurance companies?
Thank you for the question, Senator Bridle. It is challenging from a consumer advocate perspective as to why insurance companies want to continue the use of credit, since it does not indicate anything about the way that a person drives. The best thing that we can point to is that it will indicate possibly how the financial stability of that person. An insurance company is a business. They want to make money. So if someone has a higher credit score, it is likely that this person has also a higher income and an ability to protect that high credit score. In the case of an accident where a claim is filed, that person is more likely to be able to pay out of pocket for those damages and not have to cost their insurance company money to cover those claims for them.
So maybe the actuaries have shown that people with better income, higher income, not necessarily higher, but better income, make fewer claims.
I would say so.
Thank you.
Thank you.
All right, Senator Hershey?
Thank you, Madam Chair. Franz, you were just saying that you're looking for ways to get lower insurance. So does not passing this bill provide lower insurance rates?
No, but I don't think passing it does either, so I don't think it really takes us a meaningful step in the direction we need to go. I haven't gotten to make my full presentation as yet, but there are a whole bunch of reasons I don't think it offers much in the way of relief to consumers. So if it did meaningfully reduce rates to consumers, you know, I'd be happy to embrace that compromise.
Are you going to tell us then in your testimony what would bring us to lower rates?
I have ideas, but that may be beyond the scope of this bill exactly, but.
Okay.
It might be helpful for us, though,
Yeah,
as we
interesting
try
to
to
hear.
decide how to vote.
Well, I mean, what I think, you know, there's a model in California where they have eliminated, and they did this by referendum 30 years ago, they eliminated the use of non-driving factors in setting insurance rates. That includes credit, that includes education, occupation, a lot of other factors we've talked about in this committee. When they did that, California was among the highest cost states for car insurance in the country. 30 years later, it's among the lower cost states in the country for car insurance. And it operates in a way that I think is a lot fairer. They also have a program for low-cost insurance for people with good driving records and limited income, where you get a more modest insurance product at a really modest and affordable cost, like under $600 or $700 a year, and it works and it's self-sustaining even in a high-cost state like California. If we're thinking about models that I'd like to see Maryland move toward, I mean, I think that would be an outstanding model.
And that's different than MAIF?
That is different from
And
MAIF,
how
yes.
does it differ then?
Well, MAIF, I believe, uses the usual uses all of the factors that make insurance very expensive, particularly for a lot of low-income people, including credit and occupation and some other things, so that, you know, MAIF is great as an insurer of last resort, but again, it's a high-cost product that, you know, doesn't do that much to help people who are struggling to afford car insurance because it's still a high-cost product.
I mean, but at the end of the day, doesn't the amount of premiums have to be somewhat more than the amount of benefits being paid, no matter who's offering the product?
Sure, but again, you know, in the California model, insurance is still profitable in California, and they aren't using all these kind of factors that we're using. They don't have higher insurance costs.
That's not a subsidized product, though?
It isn't, actually. The low-cost insurance program is self-sustaining. People are charged $600 or $700 a year. They get insurance with slightly lower coverage ceilings. So it's meant for lower-income people without a lot of property that they need to protect. And it is self-sustaining. It's run by the insurance industry. itself. And, you know, we've had hearings on a similar proposal here, and some of the insurance representatives have said, hey, we think we could profit from that, and we'd like to get in on that. It's an idea I'd love to come back to another time, but unfortunately, that's not before us today.
Thank you.
All right. I guess we heard from everybody. No other questions? Thank
Oh,
you.
no.
Oh,
Oh, well,
no, we didn't hear from you, Franz.
Oh, I guess.
You've been answering so many questions.
Okay.
Oh, you're fine. Okay.
Well, let me try to be direct. You know, my name's Franz Schneiderman. I'm with Consumer Auto. For the record, work for safety and fairness and affordability for Maryland drivers. Look, this is a real problem that we've talked about any number of times in this committee, and people who with poor credit often end up paying $1,000 or more a year, more than other people, even if they have good driving records for a product that, you know, the state essentially requires us to purchase. The problem with this bill, and the reason I don't want to embrace it as a compromise, is all it really offers is that the promise that the insurance companies will make reasonable exceptions to their rating practices if and only if they get they are in receipt of a written request from a consumer to do so. Now, the bill itself doesn't define what a reasonable exception is, so far as I can tell. That seems to be left completely to the insurers to define. It also says that the terms of making the application will be defined by the insurer in its sole discretion. And then there's a long series of points about what kind of evidence and support you'll need, when you can make an application. This is all left completely up to the insurer. There's also language in the bill that says nothing in the bill will create a new cause of action. So I think that what I think that means is that if they refuse your request or fail to make reasonable exceptions or don't give you adequate relief, you have no legal recourse to go to court to get help. More importantly, I think, it only kicks in if and only if people make a written request to the insurance company for relief from these rating practices. The problem is that for most consumers, car insurance rates are pretty much a black box. You see what you're told to pay, and you might comparison shop for other consumers, but you don't really know what goes into the price quote you get or how. And, you know, I think most people generally know that zip code and driving record have something to do with it, but the fact that your credit record plays an enormous role, according to some studies, the largest role among any of the factors, is really not something that most consumers understand. So very few people, frankly, are going to make a written application for an exception. And even if they do, there's nothing in the law that makes clear, you know, what kind of exceptions the insurers need to offer, or what kind of relief they would offer, or how long that relief would last, or any of that. So that's why I don't think this is very useful to consumers. Just in response to Mr. Enton, as a consumer advocate, I know very well that consumers are just one of, many interest groups, many claimants here, and not the ones with the loudest voices. So, if we can get some of what we're looking for in terms of relief for consumers, that's a victory. And I understand that, but this really just, unfortunately, does very little to next to nothing to really give people relief. And that's why we're asking you to give this an unfavorable report and look at other ways to address the problem.
Okay. No questions, I see. Thank you very much.
Thank you.
Okay, now this ends our bill hearing. start. All right, good afternoon. The Senate Finance Committee is now in a voting session, and we're starting with HB 20. Nathan.
First bill on the list is House Bill 20, which increases the membership of the Maryland Stadium Authority from 7 members to 9 members by including 1 member appointed by the President of the Senate and 1 member appointed by the Speaker of the House. The President or the Speaker may remove his or her appointed member for incompetence, misconduct, or failure to perform the position's duties. Under the bill, 5 authority members instead of 4 constitute a quorum, and action by the authority requires the affirmative vote of at least 5 members instead of 4. There are no amendments and no fiscal impact.
All right. Is there a motion? Let's not have side discussions. We need to. Okay, we've got a motion to move favorable. Is there a second? All right. Did you, Senator Kramer, did you second it? Did you second it?
Sure, I second it.
Okay. All right. Is there any discussion on the motion?
Legalizing puppy mills.
Okay. If not, then, there's so few of us here. I think we need to call the roll. All right, we'll call the roll.
House Bill 20, favorable. Senator Feldman. Aye. Senator Klausmeyer. Yes. Senator Kramer.
Yes.
Yes. Senator Beidel. Yes. Senator Hershey. Yes. Senator Jennings.
Yes.
Yes. Madam Chair.
Yes.
Yes.
This bipartisan cooperation. I like it.
Next bill is House Bill 534, which passed the House unanimously and is identical to Senate Bill 244, which is up next on the voting list. So House Bill 534 requires Medicaid beginning January 1, 2023, subject to the limitations of the state budget and as permitted by federal law, to provide coverage for self-measured blood pressure monitoring for all Medicaid recipients diagnosed with uncontrolled high blood pressure. Coverage must include the provision of a validated home blood pressure monitor and reimbursement for healthcare provider and other staff time used for patient training, transmission of data, interpretation of readings and reporting, and the delivery of co-interventions. There are no amendments.
All right. You've heard the synopsis of the bill. Is there a motion?
I'll make the motion.
All right. Senator Beidel has moved it. Is there a second? Senator Jennings. Any discussion on the bill as amended, on the motion? Okay. Let's call the roll.
House Bill 534, favorable. Senator Feldman. Aye. Senator Klausmeyer.
Yes, for my delegate.
Yes. Senator Benson.
What are we voting on? 534, you're for it.
Second back page right here.
It's for blood pressure tops.
Senator Kramer.
What's this about sex? Oh, 534. Yes.
Senator
Okay.
Benson, yes. Senator Kramer.
Yes.
Yes. Senator Beidel.
Yes.
Yes. Senator Hershey. Yes. Senator Jennings. Yes. Madam Chair.
Yes.
Yes.
All right.
Next bill on the list is Senate Bill 244, which is identical to House Bill 534, which you just voted on.
So we probably could just use this, since we just voted, it was the last bill, this is a cross file. Why don't we just put the same? Okay, so we can move to House Bill 1080.
Next bill on the list is House Bill 1080, which is identical to Senate Bill 778, which is next on the voting list. House Bill 1080 requires Medicaid, subject to the limitations of the state budget, to provide comprehensive medical care and other health care services to non-citizen pregnant women who would be eligible for Medicaid but for their immigration status, and to their children up to the age of 1. The Department of Health must apply for a waiver from the Federal Centers for Medicare and Medicaid Services that maximizes federal funding and the individuals who would be eligible for Medicaid under the bill. There are no amendments.
Move favorable.
All right, we've got a motion and a second. Is there any discussion on the motion? If not, then let's call the roll.
House Bill 1080, favorable, Senator Feldman. Aye. Senator Klausmeyer.
Yes.
Yes. Senator Benson.
Yes.
Yes. Senator Kramer.
Yes.
Yes. Senator Reedy.
You support pregnant women and their babies?
Yes. Yes.
A little different than what we did on the floor, but.
Senator Bidle.
Yes, so we're helping babies, oh, great,
Yeah.
oh, I'm for it.
This one's a good one. The other one, not so good.
Helping babies.
Senator Bidle. Yes. Yes. Senator Hershey.
Yes.
Yes. Senator Jennings.
On the day after we just had a debate on abortion, yes, Healthy Babies Act, I'll support.
Yes. Madam Chair.
Yes.
Yes.
All right, now, 778 is an exact cross-file, I understand. So we could use the same vote. All right, so that now we can move down to 350.
Yes, the next bill on the voting list is the Senate bill alone, and that is Senate Bill 350, which requires Medicaid, subject to federal approval and the limitations of the state budget, to provide community violence prevention services beginning July 1, 2023. Community violence prevention services under the bill means evidence-based, trauma-informed, supportive, and non-psychotherapeutic services provided by a certified violence prevention professional within or outside a clinical setting for the purpose of promoting improved health outcomes and positive behavioral change, preventing injury recidivism, and reducing the likelihood that an individual who is the victim of community violence will commit or promote violence. Uncodified language under the bill requires the Department of Health by October 1 of this year to apply for a federal waiver to provide these services under Medicaid. And the bill takes effect July 1 of this year. The requirement to provide community violence prevention services takes effect on the date the waiver is approved and terminates if the waiver is denied.
Okay. You've heard the expert, Senator Reedy?
The hearing on this was a while ago. They said clinical and non-clinical, or can somebody just explain to me what this is? Like, what is this service? Is this bringing somebody into a family that's having problems? Is this bringing somebody into a community association? Or, I mean, what are we talking about?
So based on the testimony, my understanding is that when an individual is in the hospital who has either been the victim of community violence, or I believe under the bill there's other provisions related to someone who has witnessed community violence, they would be able to receive these services with the design of, for example, preventing future violence. And so that could take the form of the sort of non-psychotherapeutic counseling, other supportive and trauma-informed services that could help to resolve problems that led to the person's injury, or prevent similar situations from arising in the future.
Are we defining, I'm looking to see if trauma-informed is defined in the bill. I know that's a term of practice, but I'm just trying to be sure I understand what we're saying we're going to do.
It doesn't appear to be one of the words that is specifically defined under the new section established in the bill, but we could look elsewhere in the code. But as you kind of alluded to, trauma-informed care is a fairly broad term of art.
That means that the practitioner is trauma-informed.
It's that the care that yes, that the care that the patient is receiving is informed by an understanding that trauma played a role. Yeah.
Okay, I mean, we have these fun buzzwords that get used more and more now. Trauma-informed, I have heard Pedagogy is another popular one that you hear about a lot lately. Okay. So does this do anything if maybe a family has had their loved one who's a police officer murdered? Would this be available to them?
I don't know that without reviewing the bill and the fiscal note more carefully, I could offer an opinion in this setting.
Okay. We might have, we should probably, I should probably get an answer to that question since we've had some of that discussion on the floor today. So thank you.
Thank you. Nathan, could you just explain the funding for this again? You said some of it was federal, but a lot of it could be general funds?
So according to the fiscal and policy notes, should a federal waiver be granted, Medicaid expenditures would increase, but it would be 60% federal funds and 40% federal funds, general funds. And then I believe the provision in the bill specifies that if the waiver is not granted, the bill terminates. So the federal-state split would be 60-40, 60% federal funds.
And it only moves forward if they can get the federal funds. The state wouldn't pick up 100% if they couldn't get federal funds.
If the waiver is not approved, Section 1 of the Act shall be null and void without the necessity for further action. So the bill would not be effective, and so there's no chance that it would be 100% general funds.
Okay, thank you.
Questions? All right, if you're ready, did we have a motion? All right. Is there a motion?
So moved.
Okay.
Second.
Okay, we got a motion and a second in the discussion on the motion. Not, if you're ready for the questions, we'll call the roll.
Senate Bill 350, favorable. Senator Feldman? Aye. Senator Klausmeyer?
Yes.
Yes. Senator Benson?
Aye.
Aye. Senator Kramer?
Yes.
Yes. Senator Reedy?
Yes.
Yes. Senator Beidle?
Yes.
Yes. Senator Hershey? Yes. Senator Jennings?
Aye.
Aye. Madam Chair?
Yes,
Yes.
thank you. Let's welcome Pages for today. Hello. It's good to see you here. Let's see, you probably, I know you were introduced, some of you on the floor today, but tell us what your names are and where you're from.
My name is Stacy Gupta. I'm from Washington County.
Okay.
Hi, my name is Lauren Raskin. I'm from Montgomery County.
I'm Robert Sewell. I'm from Calvert High School.
I'm Alina Ayler. I'm from Baltimore County. I'm Esther Cottage. I'm also from Montgomery County.
District 15.
I'm
Okay.
Kelly Wilford, Anne Arundel County, District 33.
All right, well, welcome to Senate Finance. Okay.
Something around here.
Okay, we're in the middle of a voting session, so we're voting on some bills that we heard earlier. All right, let's return.
So House Bill 413, this is part 2 of the discussion that began yesterday. This is the bill that extends the existing state health insurance provider fee assessment through calendar 2028 to assist in the continued stabilization of the individual health insurance market. And so just to refresh everybody's recollection on this, the House put some parameters around the funds that could come from the dollars that are generated from the assessment to the reinsurance program and existing purposes and statute. And then they also adopted some study language that would require the Insurance Administration, in consultation with the exchange and the Healthcare Commission, to look at the level of funding and whether it's appropriate and some other matters. I think there was a discussion this morning that Senator Klausmeyer had with some of the carriers, the representatives of the exchange, the Insurance Administration, just about the bill. It is the case that the carriers, the position continues to be that there are some concerns about whether the funding commitment, the extension of the premium tax for the full period specified in the bill is necessary or not, and some discussion has been focusing on whether an approach that should be adopted that's been taken up in Delaware, which would give the commissioner the authority to make a determination as to whether the program was fully funded and then not collect the premium assessment based on that determination. I think the position of the commissioner is that they think that the funding allocated in the bill is reasonable. There's a lot of uncertainty about the level of federal funding that's expected in the future due to some changes with discontinuation of federal subsidies and some expectation that the program costs may not be as fully supported by the federal funding in the future. We have a letter from the exchange where they have expressed a commitment to look at this Delaware model and a study that they would be doing this summer that's specified in the bill language. I think the position of the carriers is that they would like potentially a little more specificity and direct focus on looking at the Delaware approach for consideration potentially by the General Assembly in the future, if not currently. But I think that is generally, I think, a description of the positions that were expressed this morning.
We need you to speak up and speak into your mic.
Yes, it was the bill that I held yesterday, and I appreciate everyone coming to the table this morning. I thought it was going to be about 5 people, and it turned out to be about 25 people. And at the end of the conversation, we said the insurance commissioner said that she would, when they're doing the study, there would be consideration of the Delaware model, and so that's what I anticipate. And so we have a letter, and the carriers have written a letter, and we're just trying to work on the 2 letters and see what we come up with. And it'll be up to you, Madam Chair, because you're the chair. I have a motion, yes, to pass the bill.
Okay, all right. She's moved favorably on the bill. Is there a second? Senator Bottle has moved second. Is there any further discussion of this motion?
We didn't, so the Senate didn't put any amendments on the House version at all? We're taking exactly the way the House did it? Okay.
But,
I can't
speak
read.
up so that all of us can hear, and we've got an audience of interested people.
We did not, I'd prefer not to put the amendment on, because if it goes back over to the House, of which they have said they didn't want it, and it was going to get stuck over there, and we're going to end up with nothing. So we have the letter. I have it. She looked at me right in the eye and said she would study that Delaware provision, and so I'm taking her on her word, but plus we have a letter from them. So.
Okay, Senator Reedy?
So, 2 questions. One is that, do the House amendments deal with anything regarding the fee, who the fee is assessed from? Are we keeping the fee the same? At first, are we keeping the fee the same?
So the fee is the same. It's a 1% provider fee. That doesn't change. It's continued for an additional 5 years through 2028. It's still applicable to the same entities, including the standalone dental and vision. What the House did is they did include an offset for these plans, so that there are certain regulatory fees that they pay that would be, I guess, suspended as kind of a credit in any year in which this health insurance provider fee is paid by them. That's one thing that they did that changes it a little bit, but generally it's assessing the same entities at the same level, and then there's some study language that would look at the level of funding and whether it's appropriate, and whether it's appropriately apportioned among the carriers, or should be broadened.
So that's part of the study, is studying the spread.
Yes.
And we have to do this year, right now?
Wait a minute.
Okay.
Senator Bottle had her light on first, and I'll continue.
Thank you.
Senator
And
Bottle.
that's part of the comments that I wanted to mention. We do have to do it this year, because as we move forward, next year's too late, because they're already working on the waiver. And if we're low in funding, we're gonna have issues with the waiver, and the federal pass-through dollars aren't expected to be there next year. That's why it looks so healthy. Well, it looks healthier now, it's because of the federal pass-through dollars. So if we want stability in the reinsurance fund, we need to do this, and we need to do it this year. Next year's too late.
Okay, Senator Feldman?
No, I would just to be more specific, as I understand it, the waiver has to come in, the deadline for the waiver is the end of March of 2023, but it's not like you just wake up one day and you do the waiver. I think there are actuarial assumptions and studies that need to be done ahead of time, and, you know, in theory, we could come in with some emergency legislation in January, but, you know, the risk seems pretty high. I know the folks on the other side don't think so, but it's playing with some fire here. The other thing, why don't I just leave it at that? I think the timeline here is such that, that's why the governor, this is, you know, just remind everybody, this is a bill from our governor, and, you know, just have to make that point. Yeah.
Okay, is there any further discussion on this motion? All right, if you're ready for the question, let's see, we might be able to get it. If you're in favor, raise your hand. All right, well, it's not, so, all right, let's call the roll.
House Bill 413, favorable. Senator Feldman? Aye. Aye. Senator Klausmeier? Yes. Yes. Senator Benson? Yes. Yes. Senator Kramer?
Yes.
Yes. Senator Hayes?
Yes.
Yes. Senator Reedy?
Not at this time.
Not at this time.
Okay,
Senator Beidel? Yes. Yes. Senator Hershey? No. No. Senator Jennings? No. No. Madam Chair?
yes.
Yes. 8-3, bill passes.
Okay, the bill passes 8-3, okay. Or 7-3, okay. All right, now we're going to move backwards to the beginning of the voting of the list. And pages, we have analysts who are experts in the subject matters, and they're attorneys, and they know how this matches with other areas of the law and some of the history of the legislation. So we're moving now to different analysts. Okay.
Or we play one at work.
Okay.
Okay, on the list in front of you, this is Senate Bill 833, which we went over, which you heard yesterday in some detail. Unless somebody objects, I don't think it's necessary to go through the bill in detail again. But I will go through the various sections to remind you what is in what, and then you know, you can proceed to, you know, take up sections or however you want to go regarding different parts of the bill. I received only one amendment from a member of the committee, and that is in front of you also, so that can be taken up after you go through the bill. So, again, the reprint in front of you, it's slightly different. There were some corrections from some drafting mistakes and some making sure things are in the proper order regarding effective dates and when things take effect after the voters have their say on whether to legalize cannabis in the state. So on page 1, and the numbers are in a little corner here to follow through, because if you recall, none of these pages are numbered. This first part here, this is the cannabis use baseline study, which is intended to provide a baseline analysis of the population in the state and how could it be affected by cannabis. This is the only part of the bill that's not contingent upon the constitutional amendment. This, if you pass this bill and the governor okays the bill, this will go into effect. The rest of the bill is based on whether the voters approve the constitutional amendment. And there are no changes from yesterday. You go to page 2. This is the business fund that was in the House bill as it came across. And again, the purpose of this fund is to provide help or startup help for minority-owned and woman-owned businesses entering the adult-use cannabis industry. So it's there to provide seed money for them so they can compete in the industry when an industry is actually established by the General Assembly. If you go to page 3, at the bottom onto the next page, it's a special fund, and as you see on the top of page 4, this bill actually, as amended, will have 3 special funds in it, and they're listed here, and this is all for technical purposes regarding reversion and how special funds are handled by the state budget. The rest of page 4, this section 3, this takes effect January 1st if the voters approve the referendum. It runs through June 30th, and it expires on June 30th, and it provides an interim way for the police and the authorities to deal with cannabis in that period between when it's legal and when it's in sort of a hazy period regarding particularly the personal use amount. So as you see, we went over this yesterday, there's going to be two amounts in the law going forward. There'll be a personal use amount that if there's legalization, means that a person could have 1.5 or less ounces of cannabis on their person. If you're between 1.5 ounces and 2.5 ounces, that's a civil amount, and there'll be a fine for that if you are arrested for that. And that fine would be through June 30th, it's a $100 fine. Then for a civil amount, it's going to be $250 fine going forward if you have between 1.5 and 2.5 ounces. And as we said before, it's the same penalties if you have over 2.5 ounces and you fall under the distribution part of the criminal law article. So let's now go to, and there's no changes here also as a result of yesterday's discussion. Let's go to page 6. Page 6 is what becomes law going forward if the voters approve the referendum. So as you can see, personal use amount becomes no fine. It's just going to be what will be in the law, that if you have under 1.5 ounces, that's a personal use amount, and it will be legal as long as you're over 21 years of age. And then the civil amount is maintained, that you can only, if you have between that amount and 2.5 ounces, then you could be charged with a civil offense and have to pay a fine up to $250. No changes there either. Let's go to page 8. All this new language here concerns home grow. So what also will become legal on July 1, 2023, should the voters ratify the Constitution, vote to ratify the Constitution, is you'll be allowed to grow at least 2 plants. No, not at least. No more than 2 plants in your household. Not at least. That would be interesting. And it doesn't matter how many people are living in your household. The maximum is 2 plants per household. You also have to be over 21 to grow this amount, and there's a separate penalty if you exceed that. If you exceed that amount. The rest of the page deals with adult sharing. So it allows one adult, somebody 21 or older, to share cannabis that they probably grew with themselves with another person. But again, the limits still apply. It's still the personal use amount. You cannot walk around with more than that, regardless of how you got it. On the bottom of the page, this is Section 5. This takes effect, Section 5, these provisions take effect on January 1st, 2023. And a lot of this is just conforming changes to get the code ready for the upcoming legalization of cannabis in the state. The top here just makes wording changes. Throughout the code, marijuana will now be known as cannabis. And this part here is juvenile causes. If you get on the criminal law article, there's actually a definition of cannabis established in the code, and that will take effect on January 1st, 2023. There's various changes with the oncoming legalization regarding drug paraphernalia, which are all of these next couple pages, where you see that if any paraphernalia related to the use of cannabis will now be legal under the bill. there are no changes here. If we go to page 12, again, over the years, there's been an evolution in in cannabis laws. And several years ago, there was decriminalization of up to 10 grams, which is about 3.5 ounces. There was decriminalization, so this is what this all deals with, and that is all restructured to reflect the fact that you're going to have a civil use amount rather than decriminalize anything over 10 grams. Let's see, the next page 13, this is all more conforming language relating to the new civil use amount to that section of the
Excuse
code.
me, let me ask you a question. So when you talk about the civil use amount, in other words, Maryland seems to be moving toward kind of I guess a half step, some amount, but it's limited at all times if you're remaining in legal in your handling or use or possession of it. Is that what you're saying?
I guess you could say that would be the intent here is to have a halfway between once you get to a certain level, once you're over 2.5, then you're subject to distribution, the current laws regarding the charges of distribution. So the legal amount is 1.5. So yes, you could say that that interim part is only subject to a civil fine, and that would be a half step. That would be a good way to characterize what this bill is trying to do. 3 levels. And let's see, if you go to the bottom of page 14, these are the laws that regard distribution, intent to distribute. And there are some changes here, notably regarding the production of a controlled dangerous substance. There's a separate section regarding cannabis, and you can't produce anything more than 2.5 ounces outside of any, once you get to the point where you're actually trying to create a legal industry. This applies to personal production, doesn't apply to any legal retail legal production authorized by law. And the middle of the page, you'll see that under current law, it's a felony if you're under intent to distribute. This would create instead of a felony for cannabis only, it would make it a misdemeanor subject to imprisonment not exceeding 3 years or a fine not exceeding $5,000. So it's not a felony, it's a misdemeanor. If we continue on, again, there's more changes to the existing laws regarding paraphernalia on page 16. These are all conforming changes to the new paradigm regarding cannabis legalization and the civil fines or the civil use. On top of page 17, this is criminal procedures. And again, you're just making some conforming changes here because of the civil use amounts that will come into play. On page 18, in the middle of the page, this is the part of the criminal procedure article that deals with expungement. And so obviously that's a big issue with this legislation. And at the bottom, there's new language added that is a procedure for release. If you're incarcerated for possession, this allows for simple possession. This would create a procedure for you to get released from whatever facility you are in. On the next page, there's a long list of items that you can petition for expungement for. What the changes here are a reflection of what has happened in the criminal law article regarding the use of cannabis, or a civil use of cannabis. So those are conforming changes made here to reflect that. If you go to page 20, I'm starting to have a problem seeing this. If you go to page 20, at the bottom, there's also a new provision regarding expungement for the intent to distribute, but it's certainly, you have to have been in prison, may not be filed earlier than 3 years after a person has been satisfied their sentence, so it's a little much higher standard to petition for expungement if you were convicted with the intent to distribute for cannabis. On the next page, 21 at the top, if there was this charge disposed of before July 1, 2023, that will not show up on the judicial case search. Those will all be no longer available. And then following that, there's mandatory expungement for the courts. So if a person was in possession of cannabis under the simple possession under criminal law article was only charged in that case, that charge was issued before July 1, 2023, which is the legal date for legal use. The courts would have to go through and expunge all those records, all those cases. And again, there's money in the budget. At least the House has asked for money. Again, I don't know where the budget negotiations are regarding giving the courts some funds to begin this process. Next is the public, now we're back in the public health article. And the bill establishes the Cannabis Public Health Advisory Council. The purpose of this council is to provide guidance to the state as you go into the world of legalized cannabis. And there are no changes here either.
Yes.
I just want to put out maybe for contemplation purposes with the committee with regard to the Cannabis Public Health Advisory Council, if it might be appropriate to have representatives from the Senate and the House on the Public Health Advisory Council, so that some of whatever may come of that work would be able to be conveyed to our colleagues here in the legislature, because once again, I think the public health side is something that I would like to see emphasized in whatever we do. So perhaps as we move through the rest of the bill, the committee can be thinking in those terms as to whether that might be a worthwhile endeavor or not. So thank you, Madam Chair.
Okay. Yes.
Could I ask that you go back to the expungement, page 20? Could you go back to that and explain to us again under what circumstances, if a person, now I get it, that if the only charge that an individual has that deals with cannabis, are they released immediately? Or do they have to serve up to 3 years? I see 3 years, I see 15 years, but explain to me, that piece is going to be extremely important for me in my community.
This deals with, it creates a separate standard for cannabis. So a petition for expungement of a conviction of possession of intent to distribute cannabis only, nothing else, cannabis only, under the criminal law article may not be filed earlier than 3 years after the person satisfies their sentence.
So they have to be, even though they are charged only with cannabis?
Distribution of cannabis, not simple
Oh, the
possession.
distribution.
Yeah, not simple
But
possession.
if they have it, if they are caught with possession of the cannabis,
But then there's then you can, then you could just petition for, simple possession right away.
and then they would be released.
Well, there's a separate, if you're currently serving in a prison, then there's another process here. A person incarcerated, and if you go back to page 18 at the bottom, an individual incarcerated after having been convicted of possession of cannabis may present an application for resentencing to the court. The court shall grant the application and resentence the person to be time served. If the person is not serving a concurrent or consecutive sentence, they will be released. So if you're serving currently, if you're currently in some sort of correctional facility for simple possession and you follow this procedure, the court will have to release you.
Okay, so the 15 years, if you serve 15 years, and it has to do with the distribution of cannabis, if you serve 15 years, then you're eligible to file a petition for release?
I am not an expert on expungement, but if I'm reading this correctly, you cannot file for expungement until so many 15 years after you've been released. Not how much you serve, but after you've been released, under current law for intent to distribute. So this would lower that to only 3 years if it was intent to distribute cannabis.
Okay. Vice Chair Feldman?
Since we're going along, if somebody comes up with a good idea, maybe we don't have to wait till the end. I think Senator Kramer's idea of having some legislative representation is good, although I would probably say one senator, one House member would probably be enough, but I think legislative input, so just make a note. I would suggest that. I don't know if we need to we could take that up as a formal vote after.
All right.
Okay, so we'll go, so we're moving Are we done with the expungement, Senator? Okay. So back to page 21, we're going, there's going to, well, you're going to add a senator and a delegate to the advisory council. Okay?
Can I ask another question?
Yes.
Would it be appropriate to have maybe one from each party? Just putting that out there. If not, that we can just keep sailing
Would
on.
that be a floor amendment, maybe? We'll go with what we got here.
I would think not, because you don't know in future years the relative strengths of parties. There may be a third party that's as strong as we have right now.
So when you get to the point of making some, taking some motions on these amendments, this language here in the public health will include adding one senator and one delegate, so you won't have to take that up separately. I'll just make sure that's in both bills. This would apply to both, because any changes here would automatically be incorporated in the House bill, which right now is amended to be identical to this bill. I hope. I mean, I went through it and read it. Okay. Let's move along here. So with that change to the Public Health Advisory Committee, Council, that's it. If we go to page 23, there is also established a Cannabis Public Health Fund. The purpose of this fund is to provide funding for the activities of the council. It's another special fund. That starts on the bottom of page 23 through page 24. At the bottom of page 24, under the indoor smoking ban, it would also add cannabis to that prohibition. So wherever smoking is currently prohibited by state law, smoking of cannabis would also be prohibited under state law indoors. And that takes you through to page 27 of the reprint. And here there is a new section. And this is section 6, and this section takes effect on July 1, 2023, when cannabis is legal if the voters make that choice. So the first part here, this brings in the criminal law article, and this was in another part of the bill that you saw yesterday, but it belongs here instead. So this is one of the things that had to be reordered because of the effective dates. So this deals with open containers of alcohol in a vehicle. If you go to the next page, on 28, you'll see there's a line through 1025A3. The only place you really need to specify anything after going over this with staff from JPR is B3, that an occupant of because this is designed mostly to get at open containers, but also those who are passengers in the vehicle. So this specifies that an occupant of a motor vehicle may not smoke cannabis in the passenger area of a motor vehicle on a highway. And that primarily is relating to the passenger. There is a separate part of the law, which we're going to get to in a minute, concerning the person who's driving the vehicle, and that's under Rules of the Road in the Transportation article. At the bottom of the page, this is Senator Hayes' fund, which was in Senate Bill 692. And the purpose of this fund is to put money directly into the communities most affected by the war on drugs. And if you go over to page 29, there was some talk yesterday about specifying an amount for the fund to come in. Normally, if there was legalization and you had revenues coming in, you would say so much money would go to this fund. That's not available, so this has been changed to say on line 5 here, the fund consists of revenue distributed to the fund equal to 30% of the revenues from adult use cannabis. And then there was a lot of discussion about money from the existing licensed medical cannabis growers, processors, and dispensaries as a source of funds for this fund. And the sponsor of the amendment and the bill had said that probably, and there was some to take that out. And
Can I just flush that out? And I think Senator Hayes might want to weigh in on it. Okay, so yesterday, we had Senator Augustine, made the point about that this was sort of the implication with the, certain folks by naming them would have a heads up next year. He made that point by having them, and then Senator Hershey said, you've got this language, but what are they getting out of it? And so between Augustine and Hershey commentary yesterday, that language came out, but I understand, but I'll turn to you, Senator Hayes, because we're going to rename this the Hayes Fund, if you don't mind, but, so anyway, that was the thinking because of the comments from both Augustine and Hershey yesterday, but I'll yield to Senator Hayes on
Okay,
this
Senator
one.
Hayes.
Yep, thank you, Madam Chair. And Senator Augustine, although he can't be with us, he is watching tentatively
Yes.
over the internet. So we wish he was here, but we'll hope for a speedy recovery. Madam Chair, one thing first. So what is that, Roman numeral I under 5? I think the intent was at least 30% of the fund as opposed to equal to 30% of the fund. That's
Okay.
one thing.
If you want, at least that's easy enough.
Right, at least. Right, thank you, David. The other thing is, there was a lot of discussion, but never a conversation around eliminating that Roman numeral 2, so I'd like to have that language restored.
So you'd like what?
Would like to have it restored as opposed to stricken.
Okay.
Okay.
Senator.
We don't have Senator Augustine here to respond, so it's Senator Hershey, I guess.
Okay.
No, it's.
Senator Hershey.
Well,
Get recognized again?
Okay.
The question was, so I sent Senator Augustine, I said, they're saying you requested the assessment language be struck. He said, nah, tell them that was just conversation, leave it in.
Okay, Senator Hershey.
I think I lost my partner on this one then. Yeah, I mean, I thought the comments were pretty much that, why are we requiring a group that's in the medical side to have to pay into this fund? I didn't understand where the correlation was to begin with. I mean, you know, just because that they've got into that side of this business, which this bill doesn't refer to them in any other form other than to have to pay something, and it's not clear on what it would be, you know, whether, how much it is, and I think it's just, you know, or when it gets kicked in. You know, we've gone through a number of different things on why all of a sudden is this group just, you know, having to pay into this fund, and I just, you know, I didn't see the rationale for it. I don't see what they get out of it. I don't see how much it is, when it starts, nothing. It just says that they could have to be the ones to pay into this.
Well, there is so much infrastructure that the state is going to need to provide. There's a lot that the state will need to do when you bring on any new industry, and there's so many component parts, even to figure out what to do with THC, you know, that stuff. You know.
I'm just saying, why would a medical cannabis have to pay into an adult recreational use industry?
Okay, well, I think the way the conversation yesterday got going was in the actual original bill, when we had the hearing, when we were talking about market structure and how monies were going to go into the social equity funds, one of the big funding sources in the bill as it came in was the existing licensees who wanted to get a dual license would be
sense,
kicking, you know, in, and those monies would go to a fund very similar to the fund being proposed by Senator Hayes. So it wasn't like it, you know, there was no genesis for the concept. Where you were coming from was, okay, it's not spelling that out here. And the commentary yesterday was, it's implying that that's how this will happen next year. So that was the back and forth. But I do have my own text from Senator Augustine saying it was conversation, not a formal request to delete it. But that said, Madam Chair, that's where we're at. We may need to, maybe we'll take a vote to keep it in or keep it out, or I don't know how else you want to proceed. But.
Would you like to handle it right now? You want to finish going through the bill?
Okay, why don't we could take it up right now, or we could.
It's going to go, so, I mean, we don't have to fight over this. But the point was, like you said, when it was in your bill to begin with,
right,
we were talking about the industry. We were talking about ways of which the tax revenue was a big part of your bill. Tax revenue is no part of this bill at all. So when it became that, it was a lot of the reason was, hey, the quickest way to get tax revenue that this state needed so badly was to allow those that were in the medical cannabis industry to be first in line because they have product ready that they could go out and the state could get their, you know, all-important tax revenue. So that's why there was some connection there. There's no connection anymore to the medical cannabis in this bill. And so that's why I'm saying, why should they be held to pay assessments into this fund that is strictly based on adult use, not based on medical cannabis.
Okay, well, I think that we framed the issue. We could take it up now or put this on the sort of end of discussion. Why don't we, how about this?
Why don't we finish
Why don't we
going
go through the whole
through the
bill
whole
and then we'll
thing?
come back? I
Yeah,
think that
we'll
would be
come back.
helpful.
Okay?
Discussion centered around, page 29, 5, Roman numeral to number 2.
Yes, where the slash is through.
So we need to, what, put it back?
We haven't decided.
We haven't decided. We're
that's-
asking him to
that's
go
what-
ahead and
that's what the
finish taking us
discussion
through
is.
the entire bill.
Okay.
And then we'll come back and decide.
Okay. All right, so moving on here, you go to page 30, there's a lot of, as was just discussed, there was a lot of language in the bill about the taxation if there was legalized cannabis in an industry established. That's no longer the case. So that's all struck. Let's go to page 33. This brings in the expenses disallowed under a 280E of the Internal Revenue Code for the cannabis industry. Yesterday's language focused specifically on the medical cannabis industry, and there was a lot of discussion, and the sponsor of the amendment and the bill suggested he meant it to apply to all. So you'll see new language here, and I worked on this with staff from Budget and Tax, except for the bad spelling of cannabis.
Can I wait on this one?
So it'll say, taxable year carrying on a trade or business as a medical cannabis grower, processor, dispensary, or any other cannabis establishment licensed by the state, if the deduction of ordinary, so. It just makes sure that starting in July 1, 2023, for tax year 2022, any business involved with cannabis in the state can make take this subtraction modification for expenses.
Yeah, I do, let me make a second question we can take up here at the end. So if you look at, people talk about the growers, but if you look at the sort of the processor dispensaries, I mean, here's some, 40% of the dispensaries in the state are minority or women-owned, 60% of the dispensaries are, you got a lot of small folks and independent folks. And so when I was looking at some of the B&T stuff coming on the calendar today, it was for this year. And then if you look at there was a standalone bill on this very issue in B&T, and that bill kicked in for the current tax year. And all the bills today on the floor were impacting, all those tax bills, we had like 10 of them, they all were having impacts this year. So I want to just put on the table, as opposed to this kicking in starting in 2023, that it would apply to the current tax year, like all the bills today on the floor and the Senate bill, standalone bill on those very subjects. So if we could just list that as a second question, I just want to, I take that up at the end as well.
Okay.
Okay. Let's move along here, and there were no changes there. And page 34 starts what was in the bill originally regarding driving while impaired. That's all out. Instead, there's a provisions of law in the transportation article regarding driving while drinking. This would add cannabis to those provisions. So not only if this bill passes, could you not consume alcohol while you're driving a motor vehicle on a highway, you would not be able to smoke or consume cannabis while you're driving a motor vehicle on a highway. There's no changes here too. And again, this would take effect on July 1, 2023, when cannabis is theoretically legal. On page 83.
Yes.
Before we move on from that, if I may, please. So I'm looking at, and let me ask you this. I seem to recall, and maybe it's case law, where an individual who, for instance, is sitting in the parking lot of a 7-Eleven and has been consuming alcohol, I believe, can violate our DUI laws.
Yeah.
even if they're not on a highway at the moment?
I think you're right about case law, and one of the reasons there's nothing in here about that is because of, there's language that was added that was shared with you yesterday asking for the attorney. According to folks from judiciary and judicial proceedings, the Court of Appeals is moving in a certain direction regarding this type of driving while impaired, and what, it was thought not to start to put anything in this bill that would, it's very detailed and very specific, but you have language in the back of the bill asking for an Attorney General's opinion before the start of next year on that very subject, on, on how driving while impaired and all these other things will interrelate.
So are we not going to address the prospect of somebody who, and this is already an issue, where people are pulling over in private property in parking lots and getting high? And what would be the recourse at that point for a law enforcement officer who comes upon this car and they're inside, sitting in the 7-Eleven parking lot getting high? What happens then? Or in a parking garage of a public building?
I'm sort of with you, Senator, that it makes sense to address it now rather than wait until you legalize it, and then it'll be all over the map. You'll have a lot of disparity.
And I'm trying to get a handle on that, yes, Madam Chair, beforehand, so that, because I know that after the fact can be very difficult. We've learned that lesson well. So I'm just trying to figure out if there is a way to possibly address this
Senator Bell.
as part of what we're doing today. And maybe we're moving so quickly we can't.
Well, no, I mean, look, this is an important issue, but you're mixing, there's several different issues you're kind of conflating. The issue with the AG that we talked about had to do with probable cause. In other words, if only thing that you smell maybe would be odor, does that constitute probable cause to go and search a car? Like, that's one issue that's different than it's related, but impairment, we have a transportation article dealing with impairment. Unfortunately for cannabis, we don't have the testing we have for alcohol, so that's kind of one of the challenges, and there are technology. So what's specific, I just want to make clear what's your question, because we have a transportation article specifically dealing with impairment. So if a police officer has reasonable suspicion to think that there's a crime or whatever, or probable cause to search, like, be a little more specific what we're talking about.
Okay, so specifically, there's a car parked at the 7-Eleven. The store owner looks out, he can see a bunch of guys sitting there, they're smoking, you can smell it coming from the car, there's no mistaking that odor, and calls the police and says, look, these guys are sitting here in my parking lot getting high, can you come on by? Now the officer rolls up. What is it that officer can do with regard to impairment if they're sitting in this parking lot? Is it simply, hey, move it along, you're on private property, and then these guys who've been getting high now go right out on the road because they've been told, move it along, you're on private property, you can't be sitting here doing this? Or does the officer have the ability at that point to, do whatever sobriety check there may be for cannabis? I mean, what happens?
I think the law is, first of all, if he smells odor, the case law from 2021, the Court of Appeals said, if you smell the odor of cannabis, if a person walking on the street, I said this yesterday, that alone would not be sufficient to stop and frisk somebody on the street. But when you're in a car, the rules are different. Your right of privacy in your car is different, because you're right, you can get going and you can do whatever. So the case law is different. And in 2021, the court said, if you smell cannabis, while somebody's in the car, that constitutes probable cause to search the car.
But
And-
it's legal now. So
Well,
you're
that's
not
the
s-
opinion, okay, so why we're going to the AG a little bit here is to say, post-legalization, Maryland, would that, in the formal opinion of the Attorney General, because we're still in so the case law is still pre-legalization, we want to get some guidance before next session, before all this kicks in, by the way, because next session, nothing's really happened, and if we get back here in January, we'll have an opinion, things have changed. So it's hard to codify some of this, but back on impairment, if he sees in the car or if he has reason to think the guy, the test is reasonable suspicion. If you were driving and you're impaired, whether it's cannabis or alcohol or whatever, and then, if you have reason to think the guy was impaired, then he could be arrested and and a state's attorney would have to prove beyond a reasonable doubt based on a field test or whatever. I mean, it's like
can
anything
be,
else.
But that's what I'm asking, because this is very specific to an occupant of a motor vehicle or a driver may not smoke cannabis in, I think it says passenger, whatever, it's defined as anywhere in the car of a motor vehicle on a highway. So now what's happening where these guys are all pulled over in parking lots and getting high, and there's a complaint, what are those rights? You're not on the highway at that point, you're on a private parking lot, but do you want to send them out on the highway when you know they've been sitting there smoking? I'm just trying to get a handle on whether this is something we can address now and before it becomes a big problem, that's all.
Yeah,
And if
well,
you're saying you don't think it's something we can deal with now.
I don't know I don't know that that's any different. If you see somebody drinking in the car right now, like, what do you do?
Well,
They're just sitting in the car, they're not driving, they're just sitting, we're
and
trying to draw a parallel
and that's
there.
how I began the conversation, was I believe now that they can subject them to a sobriety test, I believe. The question is, would they be able to do that under this circumstance? I'm just trying to get a handle on it.
Sure. We don't have the same
before-
kind of, we don't have the same technology, obviously, for this that we do for
No.
alcohol.
Big problem.
But I don't see any reason why the police officer couldn't ask somebody to walk a straight line, maybe if they had reasonable suspicion, and, so this is not perfect. I mean, this is an area, definitely a gray area. We're not unique. There's 19 states sort of still grappling with this eventually. So I can't really add that much
Okay.
more, Senator.
Okay, all right, thank you.
Go to another committee.
The open container law in the,
Yes. I think it is state.
so that throws another light on the subject.
That's for regarding an open container in a vehicle, that's a statewide law. And that was just covered earlier. Yeah, or smoking in a motor vehicle while. Sorry, Reedy has a question.
No.
Senator Reedy has a question.
So I'm just, based on what I'm hearing, this bill doesn't do anything to whether the smell of marijuana smoke is probable cause or not. That's allowed.
We're using case law, we're not
Right.
codifying
I
everything.
understand. We're not codifying that it's not probable cause either. We're silent. The bill's silent
We're
on that.
relying on the court
Right,
cases,
right.
yeah.
I had a question. We talked earlier about planes and also boats. And I'm not trying to be like funny here. I mean, we got boating, a lot of boating in the state, so are we gonna do we need to correct the DNR article, or is there something we need to do?
It's my understanding, going forward, there's no change to any laws regarding impairment, whether you're operating a motor vehicle or a boat. All of the existing laws that involve impairment would carry forward. Now, there might be adjustments you have to make, subsequent to that, but right now, there is no changes to any of the laws. So whatever applies to impaired operation of
Of a boat.
anything continues.
Or a vessel.
Even regardless of, regardless of this bill, that will continue. There's no changes to any of those laws. So impaired is impaired, and the current status quo will be maintained until you revisit that, if you feel that that's necessary.
Well, the reason, and just to belabor it, that's good to know that impaired would still be the same. So if you're boating while drunk or boating while high, you'd be impaired. The difference is we've talked about with marijuana, with smoke, is secondhand smoke can impair you as opposed to secondhand beer, which cannot. So, because there's no such thing. So, obviously boats, a lot of people, you can have an open container on a boat if you're not driving the boat. In fact, I think you can, I don't know what the rule is if you can be drinking a beer while you're driving a boat or not, but you can have open containers on boats and not get in trouble as long as you're not operating dangerously, as far as I know. I'm not necessarily speaking from personal experience. I'm just saying that makes sense. You can have open beers on a boat while you're traveling. So, but with pot, it's a little bit different. Now, some boats are open air, but I don't know if there's a way for us to make that clear before we pass this or not.
I'll just remind everybody this, January, this is only we could pass a law.
It won't be legal till later.
Correct,
so,
I think we have 6 months to kind of ponder some of these issues truthfully.
And then I have one other question
Or longer, 8 months.
Yeah, one other issue. I do want to go, whenever we're gonna do amendments, I would like to talk about the fines for the fines for smoking. So,
Okay.
anyway.
So that's,
Have decided that we're not going to deal with the tax issue. Well, if I look here on the page, it had a separate section that's been all blocked out here that deals with the taxing of.
There's no industry, so there's nobody to tax. You have to have an industry. The reason why it was in the bill to begin with is Senator Feldman's bill as introduced, created an industry, and part of that would be taxing that industry. So with that part of the bill struck, there's nothing to tax. So that was struck also.
Okay.
Okay. So let's go to page, and this is all you've seen before. If you go to page 83 at the bottom, this begins the uncodified language. Let's see, if the bottom of the page concerns the process of starting combining the commissions should cannabis be ratified. On page 39, section 9, this is the disparity study language that would have to occur before you create an industry and add preferences to that industry to make it constitutional, to make those preferences constitutional. On page 40, there's more studying required of the commission, and we went over that yesterday. And then there's two new pieces at the bottom here, and this is going to be tweaked a little bit. If you go to section 11, there was again concern about whether the disparity study would be completed on time. So there's language here added that the state may not issue a license to, and I'm going to add, adult use cannabis cultivator, processor, retailer, or any other adult use cannabis establishment until the disparity study is received and reviewed by the Legislative Policy Committee. And then at the bottom, this is that language that was presented to you yesterday that would require the Attorney General to develop an opinion, not just a letter of advice, but an opinion on cases involving suspicion of possession with intent to distribute cannabis, knowing, growing of all the things that are going to start happening once legalization takes place. The rest of the sections here are all enactments saying which sections become effective when cannabis is legalized, or when the voters legalize cannabis, and various. It's all technical sections regarding the effective dates.
David, quick question. Where is all this going to be housed? I apologize, I missed that. Is this the commission?
Well, there's nothing housed yet, but the language starts the process. The idea is you're going to have, Senator Feldman's bill put everything into the alcohol and Tobacco Commission. But you also going to have another commission out there also regulating cannabis. So the idea is to combine those commissions. And there's language here that would start that process of combining the commissions so they can start working together and moving one into the other. And eventually, you're probably going to have to pass laws to make that formal. But for now, this would be, they could start administratively starting to combine their efforts.
So the Medical Marijuana Commission will be
Will be
merged into?
probably folded into the alcohol.
Into the alcohol
yes.
tobacco
Yes.
Cannabis Commission.
You have to probably have to rename it, yes.
Okay, got it. All right, thank you, sir.
Senator Hershey. Yeah, just, so section 11 is where that was addressed, that if the Legislative Policy Committee does not get or does not receive a report or the disparity study prior to. Well, it basically says, and you did the same thing when, for medical cannabis, that the state could not issue any license until the disparity study was received. This is the same idea. It's, there was a big discussion about tying hands and this and that, but this just says, this is 11 on page 40. 40. Yeah. This just says, and I'm going to, so that there's no confusion at all with the medical cannabis folks, because they're already licensed and that's already going. You're going to specify adult use cannabis, cultivator, processor, retailers, whoever, any type of cannabis establishment that will come along once you establish an industry. Knows the state, whoever that is going to be, can't issue a license until this disparity study is received and reviewed by the LPC.
So it doesn't prevent policy from being done, it just says that
No, you
right.
can, yeah.
That's what I was,
Yeah.
that's what we talked about
Yeah.
yesterday.
The
You can't do
idea
that.
of saying the General Assembly can't tie their own
Just
hands.
can't. All right, thank you.
And so,
And Senator Hayes.
Yeah, thank you, Mr. Chair. I remember this conversation yesterday, and part of it, I think there's a step even before a license is issued. The commission or whoever is responsible for handing out a license will issue applications. And so I want to put on the table for consideration that the state may not issue an application for license to a cannabis cultivator. They shouldn't even be releasing any applications if the study hasn't been completed.
Okay, well, I mean, my initial reaction to that, it's going to be hard then to get into the idea of drafting a bill next year. Let's say, Senator Augustine mentioned like how long it takes to do these disparity studies. So when we sit down and we think about maybe putting together market structure, you got to have statutory language about the timelines. I don't know, like, that seems like it would make it almost impossible to craft a bill. In other words, we won't know. Well, we don't know. I mean, two things about this disparity. Number one, let's think this through a little bit. Although the language is very cumbersome on like the amount of information and why it would take so long. The AG's office, Dave talked to the person from the AG's office who's the expert, and she said that this is the sort of the broadest possible menu, that in reality, they're likely not to ask for all the information that's sort of laid out here in that much detail. So I don't know in terms of how long this process will take. So just so we're clear, just rephrase exactly what you have in mind so we can put
So,
that on the list of some issues to take up
On page
there.
40, in the section labeled 11, there's no lines on this, so it's hard to refer to it, but the section 11 is next to the last paragraph. It said, and it be further enacted that the state of Maryland may not issue a license. What I'm saying is issue an application for a license to a and the rest of it would be the same. So just put an application for license.
Just nobody can apply for a license until there's been a disparity study sent to the.
Correct.
And why would that be?
Because one, we haven't even created the industry, right? It's going to take a while for the industry to be created. The other thing is we express the importance of having the disparity study done in advance of any of this happening. You could have a situation whereas people are already applied, so you have a pool of 20 people who are applied, then you get a disparity study that, whatever the results are, but you're stuck with that pool of 20 as opposed to having the information on the front end. I think, yesterday's conversation was really focused on the front end, making sure that the horse doesn't leave the barn before we actually have a study completed in the hand.
Okay, so let's add that to, we got like 4 questions. We'll take them all up here, and let's make sure we got all of them on the table, and then we'll go through these 4 and see where we land. Anything else, or is that the last?
No, well, I don't know if you want to take up the questions and then Senator Jennings' amendment, or if you want to do Senator Jennings' amendment first and then take up the questions.
We'll let Senator Jennings explain.
Because his amendment is mutually exclusive from whatever you're dealing with here, so.
Okay, I propose we let Senator Jennings proffer his amendment, and then we'll go back and deal with these other 4.
It should be in your packet, yes.
Last page, it's just, looks like this.
It's just a simple page, there are two pages, it should be separate, I don't know if it's not attached to the reprint.
Looks just like this on the, let's read the last page. That's it.
It's the same for, but he has one for each bill, the House bill and the Senate bill. So.
Explain.
As the bill specifies that if a dispensary under the medical cannabis provision, medical cannabis, has stage 1 pre-approved dispensary is not operational as the effective date of this act, which would be, I guess, June 1, 2022. It shall become operational by April 30th, 2024. And then stage 1 pre-approved dispensary that is not operational by April 30th, 2024 may be granted a 1-year extension if the pre-approved dispensary demonstrates to the commission by clear and convincing evidence that it is making good faith effort to become operational. So I gather that the intent here is to, there's possibly a dispensary that is, has stage 1 pre-approval but can't complete the process, and it's trying to keep that approval going, especially if it demonstrates it's making a good faith effort to become operational.
Senator Hayes?
Yeah, I think Senator Kramer raised this yesterday. The amendment that I have, I think I have the right page. It says to amendment House Bill 837, but we're talking about Senate Bill 833.
Senator Jennings had one for each. It's identical amendments.
Okay. Gotcha. And so we're talking about applying this amendment that says 837 to Senate Bill 833.
Well, I don't,
For each one of them.
there's one for each one, so whatever you decide will be applied to both bills.
I got you. Okay, I see. It's different prints. All right, got it. Sorry about that. Thank you.
I do have to say, well, actually, why don't I let Senator Bottle start with the conversation?
Doesn't this apply to medical?
This only applies to medical, yes.
But our bill's about legalization of recreational marijuana. Our bill's not about medical,
Right.
correct?
So, yeah.
Counsel, correct?
Right.
Correct, yes.
Thank you.
Okay, so just playing off of that, I mean, obviously, the bill is seeking to achieve one thing. I do think that this amendment is a whole different topic, dealing with medical cannabis zoning issues, and I just think it doesn't fit within this bill, and that's just my opinion. I think maybe Senator Bottle was expressing that point of view. I think it's like a different issue that doesn't really jive with any other part of this bill, and that's just my opinion. So I can't support this amendment. I don't know, anybody else wants to weigh in on this, but.
No, I just want to ask Senator Vidal, what do you think?
I agree with Senator Feldman. It doesn't fit in this bill.
Okay.
It's medical, not recreational adult use, so I don't think it fits here. Thank you, Senator Feldman.
Senator Jennings.
I mean, cannabis is cannabis. There's no difference between the adult use and the medical side. Not with the way they process this stuff. And, you know, it's an issue that's been lingering. We're trying to get it taken care of. And I think eventually this all is going to come into one organization because I don't think the medical side's gonna last too long, because why do you need medical if you can just go out and do recreational? So,
Anybody else want to weigh in on this?
Well, actually, some of our medications now have alcohol in them, but it isn't the same thing as what you buy in the liquor store, and for those reasons, when it's, for personal use as opposed to for medical interventions. So they are different.
I think the alcohol Robitussin's different than a bottle of Jack Daniels, but, yeah, it's the
Okay,
same subject, I mean, let's be honest.
Okay.
Cannabis.
I mean, I don't know, yeah.
Okay, well, I don't want to be demagoguing this. I will, for what it's worth, and we always like to be independent here, we don't necessarily care what the House has to say, but I do know that the sponsor of the House bill is not interested in this amendment. I'm just being candid with you. So, to the extent that's relevant, I'll just throw that into the mix and maybe leave it at that. But but before we leave this, are there other issues beyond this? Is this the final issue? So then we know what the universe of issues are here?
Other than what's
Okay.
left hanging in the bill, this was the only separate amendment I received, external amendment I received.
Okay.
So this is it.
Well, it does seem like it doesn't belong in this bill to me.
Okay, well, can we start with this issue? I'm just going to move unfavorable on this proposed amendment. Well, we don't have to do anything. He offered it. Don't we have to offer? He offered it.
I mean, we got to
Senator
decide
Jennings,
what you want to take to the floor.
did Senator Jennings, what's that? Senator Jennings offered an amendment, so we have to deal with it.
Yeah, so I thought I thought somebody seconded.
All right, move favorable, let's just vote it.
Okay, fair enough. I didn't hear that. Okay, I didn't hear that. Well, it's favorable.
Okay, we'll call the roll. All right, so they've got a motion for this amendment to be voted on.
Favorable on Senator Jennings' amendment. Senator Feldman?
No.
No. Senator Klausmeyer?
Yes.
Yes. Senator Benson? No. Senator Kramer?
No.
No. Senator Hayes? No. Senator Reedy?
Yes.
Yes. Senator Vidal?
No.
No. Senator Hershey? Yes. Senator Jennings?
Yes.
Yes. Madam Chair?
No.
No.
So now you're back to the outstanding issues in the bill.
Okay, just restate the four, we got, I think, 4 issues we identified. Why don't you just restate them?
Okay, the 4 issues, I believe, correct me if I'm leaving one out here. There was Senator Kramer's adding a senator and a delegate.
Okay, I think we just, we want to take a formal vote on that. I move favorable on the Kramer amendment. To add 1 senator, 1 delegate to the Health Advisory Board. I'll move
All in
for,
favor, raise your hand.
As long as I don't have to serve, I'll vote.
no.
I think Senator Hayes would do very well.
Absolutely not.
All right, we want to see, let's
Can we put Kramer's name in the bill?
just add in the senator and a delegate.
Cool.
Okay.
What's,
Okay, and then the next one was the effective date of the tax modification. At the end of the bill, it's it would be 7/1/2023. I guess.
well, no, it's set, it would, no, it would apply to tax years, what we have in there. Okay, I'll just cut to the chase. The original bill, the bill as
Trying to make it
drafted
effective
would
this
kick
year.
in for the current 2021 tax year. This applies to your small independent dispensaries, your processors, largely, very diverse group. It's not just the bigger, it's the smaller guys too. So I think that it should kick in for the 2021 tax year, just like the 20 bills we had on the floor today, and like the Senate bill, and like the bill as originally it came in.
Okay, all in favor, raise your hand.
Okay, so the effective date of the
That's
tax
unanimous.
modification is going to be 7/1/22, and then we'll make the appropriate change to
For
effective
tax years starting.
It'll look like it did in Senate Bill 333.
833.
All tax years beginning after December 31st, 2021.
Yes.
Correct.
yes.
Which would include this tax year then.
Okay,
Unanimous.
okay. What was
Okay.
next up?
I think we're to the fund. So Senator Hayes's fund?
Right, that provision, to keep it in her.
The Senator Hayes's fund, and I want to remove the language on 5.2, which says money from an assessment on the licensed medical cannabis growers.
Technically, the Senator to be clear, Senator Feldman asked that amendment be struck from his amendment, so if you want it, you either move to put it back in, because
Yeah, I've never actually offered that amendment. I mean, it was in
Technically,
here
it's
for
out now.
discussion purposes. It was,
Right.
it was out, and then, well, it was in.
It was
It's got a
in-
line through it in here, so I
Yeah,
don't know
that
what
means
that
it's
means.
currently under what you have in front of you, technically, it's not there right now.
Then let's leave it not there.
Okay. Is that okay with everybody?
That changes my vote on the whole bill. I'll be voting no against the whole bill as a result of it.
No, just,
Vote issue by issue.
So,
let's just restate
so
it and we'll vote it.
also what I'd like to explain, Madam Chair, so there was a conversation, the Vice Chair did an excellent job at articulating the conversation back and forth between all of us, here in the committee. But in process-wise, typically, I think when you offer an amendment or whatever is to improve the bill so you could actually vote for it. I don't think any of us in that conversation mentioned to take it out, and then I come here today and that information, and that's taken out. What we explained yesterday in our conversation was this was for the purposes of those individuals who had an undue, they were already poised to enter into the system. And so if it makes everyone feel better, but, I mean, Senator Hershey's recommending taking it out, but he's not gonna vote for the bill anyway. But I think we could make it a little bit better to make sure that it's clear that if you are awarded an adult license, if you have a medical marijuana license, and you're actually awarded an adult license, which we said this will only apply to those individuals who currently have medical marijuana licenses and who have an undue advantage, who's awarded then an adult license, they would pay some type of assessment. I think it's important to keep it in there. Otherwise, I can't vote for this bill if we were to strike that language.
Okay, I hear you, because I want to support, oh, I'm sorry, apologize. Yeah, go on. I have an idea, but that's.
It's page 29.
I don't see how it's written the way that you just described it. I don't see how it's written where it says that if you get you basically said if you have a medical cannabis license and you get an adult use license, then you pay the assessment. But that's not what this says.
So what I'm proposing is this to read, money from an assessment on the licensed medical cannabis growers, processors, and dispensary that is awarded an adult license as determined by the MLA, LaPrade, medical, whatever. So to add the language that is awarded to an adult license.
Okay, that's a different, no, that's,
Yeah, it's there.
well, that's, I would support that.
Let me ask a question about that. So before, what we thought the language was, or it was that you're gonna pay an assessment if you have a medical license, because you're just gonna pay an assessment, right? That's what it was. You're saying you would only pay the assessment if you have a medical license and then you get one of these, right? My only question to that is this kind of a double jeopardy? It just doesn't feel right. It's like because you're successful, you got one business that now because you got a license, we're going to penalize you because you had a license somewhere else. I understand the side of the argument that these people may feel like they have a leg up.
Well, there are going to be legal, limited opportunities, and it's
Well,
a
why are there-
government
so that's maybe-
conferred benefit. And it would seem to me, considering that from the get-go, there are going to be more interested people and people that would be able otherwise to enter who can't. So maybe you ought to do something if you're going to get.
I'm not necessarily saying I'm against it. I just wanted to understand it better. And but the issue I'm sort of concerned about just how overregulated we're doing this whole thing, frankly. Maybe that's my discomfort. But that's better, though, than what it was. I definitely didn't think it was right that you should pay just because you have a medical license. I still not, we'll see, yeah.
I would agree. I mean, my whole concern was that somebody was paying that wasn't participating in the adult use. If the language is changed to what Senator Hayes said, that sure, if you benefited from having a medical cannabis and now you have adult use and they want to charge some to that, I think that's fine, because now you've gotten something. Correct.
Madam
So
Chair.
if that's the change, then I'm fine with that.
And I'll just add, that's exactly what the original bill that had the market structure was sending. It was the source of the funding for one of the social equity funds that are similar to this one. So that's consistent with the bill that I put in. So I think that's an excellent, I think that's a good compromise.
And I want to second it, please.
Okay, so that's where we're at.
Okay, so it's going to be money from a
Let's listen carefully now.
I'll look at the language from the previous bill, but it'll be a license who has a dual license that they have to pay directly into this fund. Okay. And that's what it'll reflect, dual licensees. The last thing is, back to Senator Hayes' change from issue a license to issue an application for a license. Okay, under the way it's written now is that a state may not issue a license to, and it's going to be an adult use cannabis cultivator, processor, retailer, or any other adult use cannabis establishment until the disparity report is received and reviewed by the LPC. And Senator Hayes would like to change that to an application for a license. So he's getting a little further, he's getting a little further into the process than just saying a license.
Does that slow it down though?
So, right, so the board would have to submit, they would have to release applications for licenses, right? And so what we're saying is, and what we've been promised, we've been promised that the disparity study would be completed by November. I think Senator Augustine most adequately articulated yesterday that it is very improbable that we're gonna have a study completed by this November, right? But the whole premises of doing this was that we would have a completed disparity study. And so we're not going, the board isn't going to issue any licenses into this until after we determine what that framework look like next session anyway. And so what I'm saying is, why would we allow them to even issue applications prior to us having a disparity study? We might come back here next January and February and a study that we were promised that was due in November isn't done in January, isn't done in February, isn't done in March, isn't done in April, right? And so what we're saying is before you go forward and put out these applications, let's make sure that we have a completed disparity study so it will help inform the process going forward.
I think that makes sense.
Move favorable. Why don't you move
I did, and it
Okay.
was seconded.
Okay.
Did we vote on it?
No, we just still favorable in a second, so.
Okay.
Sorry.
What Senator Hayes
Reed.
makes a lot of sense. I remember discussion about why we need a disparity study at all. Because it seems like we know there was an issue, or is this to try to study how to be sure it doesn't happen again? There was some consternation, I remember, from some folks about why do we need another disparity study?
5 years
So-
old study.
It's old.
I raised that question,
yeah,
and council could talk a little bit more about it. Because we had so much information from DLS, I'm like, do we really need a disparity study? But there's actually case law, and maybe our resident attorney and vice chair could speak to it, in a Richmond case that says that if you're going to have certain preferences or whatever, it has to have a study initiated prior to applying it to the law.
So, okay. I think that makes sense. Not sure whether we should have a bunch of preferences in law, but that's another argument.
Well,
for
I could
another
just
day.
add also, in fact, we have somebody in the AG's office, she's very knowledgeable about this stuff. And the most recent study we have in this subject is like 5 years old. It would be, I think she described me comical for us to go forward with licenses in the social equity space with a 5-year-old disparity study, so. Yeah, not quite the same, but yeah. Okay, well, we have Madam Chair, we have a favorable motion and a second, so.
Okay, any further discussion on the motion? All right, let's call the roll.
Is this on the bill or is?
No, it's on the, is a change. It's change.
On this particular amendment? Okay.
Do you
All
want
right,
to
well, let's raise our hands. Okay, all right. Okay. Okay, that looks like it's unanimous. Okay.
Okay, so with all that said, oh, you have another one? Okay.
My issue deals with the fine for smoking outside.
Oh, right, okay.
I think it's page 5, number,
It's
down
in
at
the bottom of page
4.
5.
Aye. So the original fine was $500. The House knocked it down to 50. You know, this stuff's going to be everywhere. They can smoke it in their house privately, but it's not fair to the rest of us. And, you know, we actually changed the laws with regards to using this stuff in the back of a limo or a bus. I think it should be the same. I don't think, I think we need to be a little harsher on this than $50. So I'd like to take it back to 500.
Got a motion, a second.
250.
All right, so that's your motion?
I'll split the difference, 250.
Well, there's two different
All-Star.
numbers. You got 50 and 150. There's a first and second. Which one?
We'll do 250 first offense, 500 second offense.
Okay.
You
All right, all in favor, raise your hands.
I'm not,
250 for one offense.
I'm not going with that.
2, 3, 4, 5, 6.
So where do we
Okay,
at?
well, you got it.
Can we do,
This is what you've been talking about. Remember how you got high and they had to carry you home?
I'm not,
We're down to 5 now.
You want them to fine them if they're doing it out in public?
I think she has to call the roll.
I think you need to call the roll, Madam
She
Chair.
has to call the roll.
All right, let's do this. Let's restate what this motion is, and then let's call the roll.
Okay, Senator Hayes?
Ask a question, what is,
What's the first time?
250.
How much?
250.
The second time? 5.
what's the penalty for the first time of intoxication of alcohol?
100, isn't it $100?
All right, I got it.
Can you just hold,
That might be bad, but it's not as bad as if you end up with THC because you're there. See, you can, because of the environment where people are smoking this, you can be harmed.
Right.
And you can end up with the residual in your bloodstream, and a week later, they think you were smoking.
This is surely gonna take us to conference
I
with the
know,
House.
because I
just wanna
know,
let you know.
okay, yeah.
Okay, so,
Oh, okay, fair enough,
Right,
but
so-
I'm not going to support this particular
Neither
amendment.
am
I think it's way
Let's
too
have
high.
can't
a
support
vote
it
on
either.
though. I think it's important enough, we should see what this committee thinks. So why don't you just call the roll?
250 first offense, 500 subsequent offenses.
All right. Okay.
Senator Feldman?
No.
No. Senator Klausmeyer?
Yes.
Yes. Senator Benson?
Yes.
Yes. Senator Kramer?
Yes.
Yes. Senator Hayes? No. Senator Reedy?
Yes.
Yes. Senator Beidle? No. Senator Hershey? Yes. Senator Jennings?
Yes.
Yes. Madam Chair?
Yes.
Yes. Passes.
Okay, with that said, I'm going to move favorable with all those various sundry amendments on the bill. And I would also say that ask that this vote count for the House counterpart.
it'll be amended to look exactly like this bill.
Okay. All right.
Are we taking up HB1? What are we doing?
Not your
All in
holding.
favor, raise your hand.
Wait, 1 second, sorry. This is not the amendment bill, we're doing that next, right? The Constitution, the referendum, we're doing that next. All right, go
Yeah,
ahead.
you're voting to amend, House Bill 837 to be identical to Senate Bill 833.
I know we're not voting two bills together,
Okay. All in favor, please raise your hand.
You don't want to do a roll call? Okay.
Do we need a roll call? We just talking about putting the two bills in the same posture.
Oh, that's fine.
Okay, all right, that's fine. All right, now what's the next?
Roll call.
Roll call on the bill.
Are we going to do the
All
actual
right,
bill?
now a roll call on the bill with all these proposed amendments.
I already,
All
I
right.
thought I moved favorable already. Okay, move favorable as amended. Second.
You guys,
Call the roll.
the other
Madam
one
Chair.
will take
All right,
roll.
we're gonna call the vote.
Senator Feldman.
Aye.
Aye. Senator Klausmeyer.
Yes.
Yes. Senator Benson. Yes. Senator Kramer. Yes. Senator Hayes. Yes. Senator Reedy.
Nay.
No. Senator Beidle. Yes. Senator Hershey. No. Senator Jennings. No. Madam Chair.
Yes.
Yes. Bill passes.
Okay, so what was that?
7-3.
7-3, okay.
All right, so.
So what do we tell them
Alright.
about the constitutional?
All right, we,
I think Senator Hayes has, the next bill is House Bill 1, but I think Senator Hayes wants to hold this bill? Yes. Okay.
What's he want?
To hold House Bill 1.
And he gets an automatic hold, as everybody
Yeah.
knows. So-
Okay, so we got a few bills left on the list, which will go very quickly.
okay.
House Bill 145, this is the stop work order bill. The House, let me get that file out. The House made some changes to the bill, which makes it a little different than the Senate bill. The House took the appeals board out of the process, so any appeals have to go to the Commissioner of Labor and Industry, and also added a opportunity for cure for the contractor and subcontractor, but after the stop order, along with the issuing of the stop order, it offered an opportunity to cure, so, and there's also a technical amendment required that has to fix a mistake in the bill, so I guess whatever Senator Beidle's cross-file, so.
The proponents ask that we approve the House version and amend the Senate version to the House version.
Okay, so this would, so you're gonna, it will be a favorable with amendment with that technical fix.
So,
House Bill 145.
Okay. So all in favor, please raise your hand. This is House Bill 145.
House Bill 145. It's prevailing wage stop work orders.
Okay, all right, and those opposed, raise your hand. Okay,
Okay?
okay.
And the next bill is House Bill 580. This is also a cross-file to Senate Bill 475. This deals with the supervisors and sergeants of the Maryland Transit Administration. The House did a lot to this bill. They actually struck the bill and added that these employees would actually not be subject to bargaining under the transportation article, but subject to bargaining under state personnel and pensions. Senator Beidle is the sponsor of the cross-file, and I believe she has a amendment or a motion.
I'd like to motion that we amend the Senate bill to look like, amend the House bill the way the Senate bill left here. So we conform it to the Senate bill.
And I'm a little confused at the moment. Are we going to be voting tomorrow so that maybe Senator Beidle and I can have a conversation to make sure we're all on the same page here? Can we just hold it and then you and I will have your bill's moved.
Right.
And and your proposal is to put it into the same posture as the Senate bill. But I'd like to, can we hold it till we vote tomorrow?
Okay.
You comfortable?
Am I happy? No, but you can.
Oh.
All right, that's your hold.
Okay?
Okay,
I'd like to hold it, let's have a conversation.
okay.
Okay. And the next bill is House Bill 609. This concerns the local health officers, removal, grounds, and process. Again, the House bill is different than the Senate bill, but my understanding is the House is moving this Senate bill clean. So if you want to conform.
I move to conform the House bill to the Senate bill as it left the Senate.
Yeah.
Did I say that right?
That's correct.
Okay, is there a second?
Senator Hershey, the Senate amendment.
Clarence Lamb talking on the floor about this?
No, they're moving.
I'm sorry.
I think it was just trying to be helpful.
If we vote this bill, 609, it's clean the way it came into the Senate, right? The House didn't make any amendments.
Yes.
And it would just be a clean bill. Basically, it says that the health officer has to have some experience in health. Could be public health, doesn't have to be a doctor.
No, this has nothing to do with that. This is the grounds for removal.
Okay.
Okay.
So let me restate, I move that we conform the House bill to the Senate
Yes,
version.
yes.
That get left here with the amendments. Okay.
All right, so is there a second?
Senator Hayes is generously second.
All right, all in favor of that motion, please raise your hand. Okay, that's unanimous.
Okay, and the next bill on the list is prevailing wage applicability. This deals with the service contracts as part of a public work contract. Senator Feldman was the sponsor. The bill is identical to Senate Bill 259. Yeah.
Feldman, Valderrama, Bill. Wow.
Move favorable. Second.
Okay, all in favor, please raise your hand.
Party line.
I'll be voting against adding costs to it.
Oh, okay, let's call a roll then. Just call them.
House Bill 611, favorable. Senator Feldman?
Aye.
Aye. Senator Klausmeyer?
Yes.
Yes. Senator Benson? Yes. Senator Kramer?
Yes.
Yes. Senator Hayes?
Yes.
Yes. Senator Reedy?
No, thank you.
No. Senator Beidle?
Yes.
Yes. Senator Hershey? No. Senator Jennings?
Negative.
No. Madam Chair?
Yes,
Yes.
Okay.
okay.
David, there was that joint
Oh,
bill.
that's right, I'm sorry. No, this is easy. You're second on a House bill, it's 28. It's the bill that, regarding nicotine replacement therapy. The HGO passed it with a very small amendment, limiting it to small, or not HGO, passed it with a small amendment, small doses of. They voted all in favor of it down there, and you also approved of the Senate bill, the cross-file. You were second on it because of the nicotine aspect of it.
This is House Bill 28.
This is House Bill 28.
Okay, do we have a motion?
Second. Anybody go?
You're second on it because nicotine, because of the subtopic of nicotine. EHE. They're favorable. With an amendment. They are favorable with an amendment. Yes, unanimous.
All right, it was unanimous with an amendment in EHE. We're okay?
I'm okay.
House
David,
Bill
what is-
28.
What does it do?
Oh. It authorizes a pharmacist who meets requirements of regulations adopted by the board to prescribe and dispense nicotine replacement therapy medication. It basically authorizes them to do it. Normally, you'd have to go to a physician, so it's one of those times when you're giving a pharmacist additional scope of practice
Right,
responsibility.
okay. All right, so is everybody okay with that? Raise your hand. Okay. All right, that's unanimous. All right. Hold just a second, don't go anywhere. Tammy's picking up something that she said we need to deal with.
That's quite the change on those fines.
Patrick has one more thing. The bill from yesterday that has a
Jill's gonna
slight
have a
amendment.
fit on the floor.
Okay,
Patrick's coming.
all right. We're waiting for the other analysts. Don't go, we got one more bill. Yeah, we're done with everything else. They're just waiting for you. Tell them at least the bill number, tell them something.
So we had House Bill 962.
Okay, could you come to order? Thank you.
We had just one bill, House Bill 962, which was on a consent calendar. It's the Commercial Law Maryland Personal Information Protection Act bill. And it turns out that it actually needs a technical amendment on the bill to match what was put in the Senate bill. So we just need an amendment to that bill for the technical amendment. Puts the bills in the same posture.
Oh, okay, can we get a motion to do that?
Move favorable.
All in favor of that motion, please raise your hand. All right. Thank you. That's unanimous. Okay.
That ends our voting.